that order was, my lord, challenged in appeal, my lord, under section 9 of the said act. Now, during the pendency of the appeal, my lord, the railway authorities, my lord, prayed before the court, my lord, page 46, my lord, praying for time to file the written statement. Now that application was rejected, my lord, next page 47, by stating that, my lord, under the Public Premises Act 1971, my lord, there is no provision to file written objection. So against that order, my lord, I have preferred this, my lord. The railways have preferred this petition. My lord, if I may take, my lord, to the provisions, my lord, my humble submission is, my lord, since the section 9 court, my lord, the appeal which is filed under section 9, under, my lord, if I may take, my lord, to section 10 of the Public Premises Act, my lord, Public Premises Eviction of Unauthorized Occupants Act 1971. Section 9, my lord, if I may read first, my lord. Section 9, my lord, subclause 4. Every appeal under this section shall be disposed of by the appellate officer as expeditiously as possible, and every endeavor shall be made to dispose of the appeal finally within 1 month from the date of filing the appeal, after providing the parties an opportunity of being heard. Now, my lord, subclause 6, for the purpose of this section, a presidency town shall be deemed to be a district and chief judge or the principal judge of the city civil court therein shall be deemed to be the district judge of the district. Now, my lord, coming to section 10. My lord, section 10 gives finality to the order passed by the appellate authority under section 9. If I may read, my lord, section 10. Save as otherwise expressly provided in this act, every order made by an estate officer or the appellate officer under this act shall be final and shall not be called in question in any original suit, application, or execution proceeding, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act. So therefore, my lord, my humble submission is, my lord, that the authority should be given full right to file objection and defend by giving all necessary documents, so that, my lord, subsequently we are not deprived of that right, my lord, because section 10 gives finality to the orders. So, my lord, the principles of natural justice and full opportunity of being heard, that would mean, my lord, that the authorities have right to file the written objection and submit their pleadings along with all necessary documents to support that it is a railway land. Because subsequently, my lord, we will not have that opportunity in view of section 10, which gives finality to the order. So, my lord, the rejection by the honorable court below, my lord, denying that, stating that we have no right to file written objection, my lord, that is under challenge, my lord. And, my lord, in support of my
Admittedly, in the act, no provision is there.
But, my lord, section 9 court is a civil court, having all powers of a civil court. That is also held, my lord, in the judgment, my lord, in one of the judgment, paragraph 39. My lord, if I may take, my lord, to paragraph 39. Let me read, my lord.
Yes.
My lord, 39, paragraph 13. My lord, indeed, the expression used in section 9 is appellate officer and not appellate authority, as has been used in section 6C of the Essential Commodities Act 1955, considered by the Supreme Court in Thakurdas, that however would neither make any difference nor undermine the status of the district judge or the designated judicial officer so as to reckon their appointment as a persona designata. The thrust of section 9(1) is to provide remedy of an appeal against the order of the state officer before the district judge, who undeniably is a pre-existing authority and head of the judiciary within the district, discharging judicial powers of the state, including powers to condone the delay in filing of the appeal and to grant interim relief during the pendency of the appeal. Though described as an appellate officer, the district judge for deciding an appeal under section 9 can and is expected to exercise the powers of civil court. Therefore, my lord, the right to file written objection is very much there, my lord.
The other side has preferred an appeal before the
Before the
district judge.
district judge, my lord, against the order passed by the railway authorities.
Yes.
In that, my lord, they have
And
taken
appeal.
appeal.
You want to file cross objection or cross appeal or what?
Written objection.
Written objection. Written objection against what?
My lord,
Against any finding recorded by the state officer?
No, my lord, in the pleadings which they have filed in appeal, they have stated certain new facts which were not placed before the state officer. So if we do not get that right to file objection, my lord, it will attain finality and future, my lord, there will be no appreciation of evidence subsequently.
They have raised some new pleas,
my lord,
in the before the
appeal.
state officer. No, you have appeared there. You have contested the proceeding before the state officer.
Yes, my lord. Yes.
Then?
But in appeal, my lord, we want to file the written objection.
No, written objection against what? Against the finding recorded by the state officer?
No, against the appeal, the pleadings made in the appeal by the person who is occupying the.
Show me any provision. Person to which you are entitled to file objection against the
that is what
appeal file by the other side.
Since section 9 code is a civil code, as
that's all right. So me from the CPC, is there any provision? Provision is there for filing cross objection, cross appeal.
My lord.
But to file a written objection against the memo of appeal filed before the appellate court, is there any provision?
My lord, that is what I am trying to submit, my lord.
No.
This appeal, my lord, if my lord sees section 10, it attains finality, my lord. Therefore,
no, merely because under as per section 10 of the Act, the finding attains finality. Can this court, can the appellate court allow you to file an objection against the memo of appeal?
The appellate court has, my lord, full powers to adjudicate afresh the entire matter.
The appellate court has to exercise its power within the parameters of the CPC. You show me any provision if it is there. There is provision for filing cross appeal.
Cross objection is there.
Cross objection.
Yes.
Your objection falls in which category? Cross objection or cross appeal?
No, since it is a special, not cross appeal, my lord, neither cross objection. It is, we simply want to file a written objection.
You show me any provision.
But so far as, my lord, the powers are concerned, my lord.
Where the court will derive the power? From the CPC?
Yes.
If there is no provision in the CPC, then?
Well, court can exercise the inherent power also. Under 151 allow us to file the written statement for the interest of justice, my lord, and for full opportunity of being heard. That is there.
It is not your case that you have not given the opportunity of being heard there.
Well, we have not been allowed to file.
Maybe, but you can argue the matter.
Fixed for final hearing, yes, my lord.
Yes.
But my lord, since if we are not able to bring the relevant documents, subsequently, my lord, in any proceedings, we will not be able to substantiate the ownership of the railway, my lord. That is the submission, my lord. Because
you have got full opportunity before the state officer.
A state officer,
and you have availed it.
We have conducted. We are the authority. A state officer. Then this is against the state officer's order. My lord, they have come in appeal. So, my lord, our humble submission is that, my lord, we want to place all the documents on record before the appellate court, so that the appellate court, my lord, do not come to any adverse conclusion against the authorities, my
No,
lord.
no.
Our simple, my lord, prayer is to allow us to bring by way of a written objection.
Okay,
Written-
you show me any provision, we'll allow it.
My lord. But so
We'll
far
pick
as-
it up at 2 o'clock. In the meantime, you go through the provision.
my lord. 1 to 4 same, my lord.
Come prepared at 2 p.m.
My lord.
Against for orders, item number 10.
In between.
I for the appellant, your lordship.
So service completed here.
Yes, your lordship, one development has been taken place because this appellant died
Okay.
on 3rd December 30. December 30. And we have filed an IA for substitution of the legal years.
When?
In this proceeding.
When
but,
did you file it?
But it is not tagged. It was filed on 3 February 2026. I got a registration number on 19/02/2026. So it is not tagged.
Heard, Mr. Your name, please.
You does.
Learned counsel for the appellant, Miss. For the respondent. Mr. Eudas, learned counsel for the appellant, submits that the appellant, namely
Matram
Matram Sutia, suffered demise on
30/12/2025.
12/2025, and he has filed one application for
Substitution
substitution of the said appellant
on 3rd of February, your lord.
on 3rd of February. But the said substitution application has not been placed on record, and accordingly it is provided that recessal lays the matter on next Monday,
Lordship. Okay.
along with the application for substitution of legal heirs of the sole appellant.
Much obliged, your lordship.
Item 11.
Is your lordship?
Hmm.
Lordship, stay has been taken
When?
on 12th March.
12th of March.
Lordship?
12th of March.
Yes, Lordship.
Heard, miss, your name, please.
Deepsikha Devi, D Devi.
D. David, learned
On-
counsel for the appellant. Office note dated 30/3/2026 indicates that neither ID card nor unserved notice in respect of sole respondent received by the section till date. Accordingly, it is provided that recessal lays the matter after vacation, awaiting service report upon the respondents. How many respondents are there?
Uh.
Sole respondent. Upon the sole respondent. After vacation.
Much obliged.
Item 12.
May I please, sir?
Yes,
Service is completed here.
service
And-
completed.
Yes. And scan copy are called for, but I have not seen.
Some order has been issued from the time.
I sent you.
Okay, scan copies of the orders received.
All order copy.
So we will list it for admission hearing.
Yes.
Heard Mr. Upadhyay, learned counsel for the petitioner, and Mr. Parekh,
K.
K. Zain, learned counsel for the respondent. It is submitted at the bar in this that in this matter service is completed and the scanned copy of the record also been received from the learned court below, and as such the matter may be listed for admission hearing. Accordingly, it is provided that recess allays the matter in the column admission hearing after vacation.
After interim order is there.
Interim order pass earlier shall continue. Okay.
24, yes.
Item 13.
The service report reflects that service upon the respondent number 2 is yet to be completed, madam.
Okay. You have for respondent number
1.
1. Heard, Mr. Your name, please.
A. Roy, my lord.
A. Roy,
Yes, my lord.
learned counsel for the petitioner, and Mr.
And Kolita on behalf of A. Kolita.
N. Kolita, learned counsel, appearing on behalf of Mr.
AIL.
AIL, learned counsel for the respondent. Office note dated 38/3/2026 indicates that service report in respect of respondent number 2 is awaited. Accordingly, it is provided that recess allays the matter after vacation awaiting service report upon respondent number 2.
The interim order may be continued.
Interim order pass earlier shall continue.
14-15, my lord, similar.
15 is also similar.
My lord,
15 is also similar.
same. 14 and 15, similar plus.
Okay. 15 similar.
Item 16.
My lord, interim order,
In 15 also there is interim.
yes, 15.
Okay,
13,
interim order
14,
passed
15, interim order.
earlier in item number 15 shall continue.
Item 16.
Might be please. Also, when this made, TCR was called for and step was taken by the petitioner upon the sole respondent.
Heard, Mr.
Peter Puri.
Learned counsel for the petitioner. Office note dated 38/3/2026 indicates that neither service report, neither edit card nor answer notice issued to the respondent returned received by the section till date. Recess allays the matter after vacation awaiting service report upon the respondent. The site office note also indicates that scanned copy of TCR has already been received by the section. List after vacation.
So that may fix for you because in this matter the stay order is not there, interim protection, because it is
Okay.
the transfer petition you wanna.
29.
Sorted.
24 different.
Must complete.
Item 17. Yeah.
On. After some time.
Yes. Item 20.
My please, your lordship. My lord, at this stage, my lord, the delay, my lord, notice may be issued, my lord. 2,912 days delay, my lord, including COVID period, my lord. And the petitioner was, my lord, suffering, my lord, the paralysis And in 2002 stroke was taken in 2013, my lord. Medical certificate pays 9, my lord. And the certificate, final certificate is pays 35.
This application is for
My lord, this is for application for condonation of delay, my lord.
condonation of delay.
My lord, my RSA was dismissed for default in 2000, my lord, 18. 10/1/2018.
Heard, Mr. Ali, learned counsel for the
M. Islam.
M. Islam, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 2,912 days in filing the application for restoration of RSA number 12 of 2009, which was dismissed for default on 9th of December 2020. When it was dismissed?
My lord, dismissed on 10/1/2018.
Dismissed on 10/1/2018. Let notice be issued to the respondent, stroke opposite party, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today, list of documents.
Highly obliged, your lordship.
21.
May prior. Matter may be kindly pass over time.
Who will appear?
Kanak Sharma, sir.
Who will appear?
My senior K. Sharma. The appeal has already been admitted. No?
Waiting for admission, item number 5. I forgot this one.
Petitioner is there? None appears for the petitioner on call. How about Mr. Learned counsel for the respondent present. List the matter after vacation. In the event of subsequent non-representation of the petitioner, appropriate orders shall follow.
Map your lordship. Lordship, the petitioner is a tenant under the respondent since the year 1995. 31 years he has been the tenant. The suit was filed by the landlord for eviction and for recovery of area rent. The suit was decreed. We filed an appeal. Appeal was dismissed, Lordship. So against that, we have filed this revision. The appellate court judgment is at page 72. Page 73 starts from page 73. May I read it, Lordship? Title appeal number 10/21 has been filed by appellant defendant under order 41 rule 1 CPC against
First, tell me what are the grounds? What are the grounds?
Lordship, we have categorically stated that we have been offering the rent and on refusal, we have deposited the same. The learned court held that I have failed to adduce evidence as regard the date when it was offered, when it was refused. Lordship, in this respect, before the judgment, we filed an application before the appellate court under Order 41 Rule 27 to adduce additional evidence. It was filed before 2-3 years before the judgment that we want to adduce additional evidence because the learned advocate has not categorically stated the date. Although he has stated that on refusal he has deposited the rent in the court, but the date was not mentioned and who accompanied him while offering the rent, those facts were not mentioned. So we file an application under Order 41 Rule 27 that we may be allowed to adduce additional evidence. That petition was rejected and on the same day appeal was heard and the appeal was dismissed. In paragraph 19, court has categorically held since there is no evidence. Para 19, page 88. Para 19, page 88. Since there is no evidence to show that the rent was offered and the same was refused by the plaintiff, the deposit of rent in the court cannot be considered as a valid deposit. My lord, that is why we file an application that we want to.
First, let us see your WS
Lordship,
page number
page 27.
27. Where is your averment in respect of offering the rent to the landlord?
Lordship, page 29 J, that since the month of J, I, that finding no other options has the plaintiff refused to accept the rent, the defendant has deposited the rent for the month of April in the learned court. That since the month of May 2000, the defendant has been offering the monthly rent of 2000 each and every month within first week of the succeeding month to the plaintiff, but in every month he refused to accept the monthly rent from the defendant, and so the defendant has been depositing the rent in government treasury through the learned court till filing of this WS.
No, in the written statement also nowhere you have stated how and when you have approached the landlord to accept the rent. So by filing such an application, can you supplement it now?
Lordship, I filed an application that the persons who accompany me, they will adduce that they have accompanied me while offering the land.
No, okay. Even if that petition was allowed, can the same be taken into account while there is no averment in your pleading?
The dates are not mentioned, Lordship.
Dates are not mentioned.
Dates are not mentioned.
Then
But we have categorically stated that we have offered in the first week of the succeeding month.
where you have mentioned first
J.
week of succeeding month.
Within every month, within first week of the succeeding month. In the second line of para J.
There is a how and at what time and at which place you have offered the same? There is no mention in the
That is not there, Lordship.
then. Mhm. Where is the order of rejection of your application?
That is at page 61.
67. 67.
Operated portion is at page 71.
In fact, in that particular petition, they had said that the first week of month, which is just now named by my,
Pardon?
the first week of month,
Mm.
of every succeeding month, Then in that particular petition, they say that they abruptly used the particular word. And the learned advocate missed it. So now they cannot claim that it was there in the first week of every succeeding month.
So when an application under order 41 rule 27 can be allowed? Hmm? The trial court has discussed the matter, referring to a decision of Supreme Court. What wrong with this finding?
Lordship, in
Hmm?
paras 15, trial court said that I find that the additional evidence sought to be adduced is not required to decide the appeal. And in the appeal, the same court find that there is no evidence. As that is the evidence that I intended to adduce.
No, in this decision, Haryana State Industrial Development Corporation versus MS Cork Manufacturing Company. AIR 2008 SC 56, where it is held that Order 41 Rule 27 of the CPC also does not empower an appellate court to accept additional evidence on the ground that such evidence would not be produced or filed either before the trial court or before the first appellate court due to inadvertence or lack of proper legal advice. Can you file such an application to supplement the evidence and the averment which are not there in your pleadings?
We have, in our application, we stated that these things were stated to our advocate, but he has not incorporated in the WS. That was our application, Lordship.
Whether you have filed any complaint against
No,
that counsel?
no, that is not there. I
Then-
have to admit that is not.
Why should we accept your submission then?
In fact, that application came to be filed after 3 years of filing of the written statement.
And what are the other grounds?
Lordship, as far as other grounds are concerned, Lordship will see that in the page 24, para 8. Para 8, may I read it, Lordship? As regard bona fide requirement. Right, the shop room mentioned in Schedule A is one of the 4 rooms of the RCC building. One of the 4 rooms was used as an entrance to the adjacent residence of the plaintiff. The room which is used as entrance to the plaintiff residence has fallen in the share of Rajkumar Sahu, elder brother of the plaintiff. Now, due to strained relationship with the said Rajkumar Sahu, the plaintiff is ordered to arrange an alternative entrance to his residence. The plaintiff has no alternative to arrange new entrance except the shop room mentioned in the Schedule A. The suit shop is bona fide required to the plaintiff for his own use, has entrance to this residence. So, Lordship, his category case was that he want the shop premises to use as a entrance. But Lordship will find that at page 44, para 23. Page 44, trial court judgment, Lordship. Page 44, para 23. Lordship, para 20, the plaintiff main contention in the present suit is that the suit premises is required for its own use and occupation. The plaintiff has no other accommodation for running a business to earn livelihood. So the learned court has he has never sought the accommodation to earn his livelihood. Again, in page 45, para 27. Here in the present suit, also the plaintiff has the privilege to choose the place of business. He did not want the suit premises to run a business. Lordship, there we have categorically stated in our WS that there is an alternative route for his entrance. And his wife is a government employee, and he is doing a job in some private firm. So he has not stated that he will do any business nowhere.
No, there is a decision of Supreme Court where it is stated that a landlord is the best judge of his requirement for residential and business purpose.
The Lordship may kindly say page 88. The affiliate code judgment.
Page
88, Lordship. Para 20 onwards.
para.
20
Hmm.
of the appellate court judgment. There it is categorically stated, observe that
Okay, first let him complete.
Lordship.
Thereafter, you may continue. Yes.
So my contention is that I have exhibited all the NJ cases where deposit of rent was made in time. We have made a categorical statement that on refusal, we have deposited the rent in the court.
Hmm.
And Lordship, most important issue, the plaintiff claim is that I came into tenancy during the lifetime of his father. But our stand in the WS was that initially Mathura Prasad Sahu was the owner. We made a advance deposit of 1,20,000 to him, and thereafter, after his death, the suit premises came into on the basis of family partition. It came into possession of the plaintiff's father, and thereafter, plaintiff's father started to take the rent, and after his death, the plaintiff and all. Lordship, the stand that we have paid 1,20,000 has not been denied by the defendant plaintiff in the cross. He only said that yes, Mathura Prasad was the original. He admitted. He stated that he has not informed him that he has ever received the security deposit of 1,20,000. Further, the plaintiff in the suit stated that he took a loan of rupees 35,000 from me as a loan, and that was adjusted in the rent. I don't know how it was adjusted. Nothing is there in the evidence how the rent was adjusted. And my categorical case was that 35,000 additional amount was paid to plaintiff's brother Shiv Kumar.
No, you see, this is civil revision petition. Here we are not entitled to appreciate the facts. We will only examine the
Lordship,
correctness of
whether
the
there
finding recorded by the
issue was
appellate
not
court.
framed, has whether there was an advance paid to him, whether those advances were adjusted against the rent.
No, this court is not entitled to examine that aspect. From the judgment of the appellate court, you demonstrate before this court what are the illegalities or infirmities there in the said judgment.
Lordship, my categorical case was that I have paid an advance. That issue was not adjudicated. There no issue was at all was framed. Whether
that,
I paid
that issue you could have raised before the first appellate court, not before this court now. This is not second appeal.
And in my petition, I have specifically stated that I want to adduce additional evidence of 2 persons who accompany me while tendering the rent, Lordship.
Any other ground?
Lordship, I have an alternative prayer. Lordship, may kindly come to page 46. Lordship, may kindly come to page 46. Lordship, may I read the order portion? In view of the discussion made above and the decision reached therein, the suit of the plaintiff is decreed on context with cost. It is hereby decreed and declared that the defendant is a defaulter in the payment of rent, and as such he is liable to be evicted. The defendant do vacate and hand over the suit premises to the plaintiff within 2 months from the date of the decree, or else the plaintiff would be able to execute the decree. The period of 2 months is granted to the defendant so that he could make some alternative arrangement. My prayer is that, Lordship, I am in the suit premises since 1995, 31 years. 2 months will be too short. I may be given till December, we will vacate the premises. Because I have credit sales, I have to recover my money from the market. I have to search for another shop. I am a senior citizen now. Some reasonable time may be given. I am in the suit premises since last 31 years, Lordship. Okay, yes.
She had already seen regarding the defaulter effect of payment. And in respect of the bona fide requirement, your lordship will find the observations of the appellate court at page 88, paragraph 20. There, the appellate court has made a categorical observation. Para 21. May I read from you?
Para?
The 20 of page 88.
Yes.
The plaintiff pleaded and testified that the suit premises is required by him for using the same as entrance premises. He further pleaded and testified that previously one of the four rooms in the building was used as entrance to his residence. The room which was used as entrance has fallen in the share of his brother Rajkumar Sahu, and due to the strained relationship between them and Rajkumar Sahu, he is ordered to make alternative arrangement for entrance. The same fact is testified by the plaintiff, and his testimony that the room is required to be used as entrance could not be impeached by the defendant. The testimony of the room which was used as entrance falls in the share of the brother of the plaintiff, and at present there is strained relation with the said brother which could not be impeached by the defendant. The defendant merely properly recorded that the rooms in the building and saying have been let out by his brothers to other tenants. The fact that there are rooms in the building falling in the share of the brothers of the plaintiff does not show that the room is not bona fide the requirement of the plaintiff for his entrance, when the plaintiff has testified that due to strained relation with his brother, he is to make arrangement of entrance through the premises. In Pratibha Devi versus Devi Krishnan, 1995, 5 SCC 353, the Honorable Apex Court held that the landlord is the service, and the permanent courts have no concerns to dictate the landlord as to how and what will leave. It is settled position that the bona fide requirement of the landlord has been heard by the court sitting in the chair of the landlord, and not as merely raised by the defendant. The instead case the need of the plaintiff to use the premises as entrance to his residence as the previous entrance brother with whom his relation has strained is a bona fide requirement of the plaintiff. Mere availability of rooms to be used as entrance which falls in the share of brothers of the plaintiff does not show that the plaintiff does not have a bona fide requirement on the suit premises. The mere availability of any road on the backside of the building does not negate the bona fide requirement of the plaintiff to use any front entrance to his residence. The defendant cannot dictate the plaintiff to use any back entrance or property of his co-sharers as entrance while he has his own property, which can be used as for front entrance only for the reason that the same has been laid on to the defendant. In view of the facts, I find that the plaintiff has a bona fide requirement to the suit premises. So there is no informity or illegality in the order passed by the trial court as well as the appellate court. Though the learned trial court failed to discuss to the bona fide requirement in proper manner because it said that it was required for business purpose, but in the plain file by the plaintiff it was stated that it was required for entrance purpose, but the appellate court has made categorical observation in respect of the bona fide requirements. Observing and considering the statements made in the plain and the written statement filed by the defendants as well as the evidence led by both the parties. In respect of the application under order 41/27 for finding additional evidence, the evidence states your lordship, this seen in the order passed by the London Appellate Court. At page 63. At page 29 of the petition, your lordship will find that there was no specific date pleaded by the defendant in the written statement with respect of the payment of the rent. Page I and J, these three are relevant. Page 29. And in fact, in page 31, para number 14, the last para your lordship will find in page 31, para 14. Thereafter, in each and every month, the defendant offered the rent to the plaintiff and on refused to accept the same by the plaintiff, the defendant has been depositing the monthly rent in summary subsidiary. So, honorable court, by filing miscellaneous and the case number, cases in each and every month, as the defendant is not a defaulter. So, in fact, there also there was no pending in respect of the payment. No specific date was mentioned when it was offered and when it was refused. And the written statement was filed on 15/9/2017. The trial court passed its judgment on 25/2019. And in that particular judgment passed by the London trial court made an observation and directed the defendant, to make an alternative. Now, after 7 years of this trial court judgment, they have put on an alternative arrangement, and now he has played before this honorable court that some time may be granted for him to make some alternative arrangement. In 7 years, they could have made some alternative arrangement.
The question is, can this court grant such time to him?
That time, that is already granted by the London trial court. And that is over because in 2019.
No, I am asking you whether this court can grant such time to him.
No, in civil division petition, your lordship will find only see or consider the legality and correctness of the order. In my respective submission, this court cannot grant such.
Okay, any reply?
Lordship, taking into consideration that I am in the suit premises since 31 years and after the trial court judgment, I was pursuing legal remedy as permissible under the law. It's not that we are delaying. The application for adducing additional evidence was immediately filed on filing of the appeal, but it was taken up after 3-4 years. That was not because of our.
No. That can be considered only at the time of hearing of the appeal, not prior to that.
Appeal was not heard actually. So, Lordship,
There is no provision for hearing the same.
As
There are
regard,
several judgments of Supreme Court.
power of this honorable court has inherent power, and in fact, we have come across cases where Supreme Court also grant times, and this court has in multiple cases given sufficient time for searching for alternative accommodation also.
Okay, you produce any of the decision, we will consider it.
Lordship, tomorrow,
By
Monday,
tomorrow?
Monday,
Tomorrow is holiday.
tomorrow is and Monday. I will-
Monday you can,
Only on this point, only on this point.
but we will not list the matter, you furnish the decision
Yes,
to
I
the
will,
court master.
I will furnish. I will-
Heard Mr. Kandalia, learned counsel for the petitioner, and Mr. Bora for the respondent. Argument concluded, order reserved.
Must.
Item 31.
May I please, your lordship? The petitioners are the defendant in the title suit, lordship. The petitioners have
What is the impugn order?
impugn order page 44.
Page
44.
44. Yes.
Lordship, today my submission is that there is no interim order in this civil division for the petition. The suit has proceeded and now it in evidence stage. And the issue raised by that petition
Mm.
or under order 7/11, but the issue has been framed by the learned trial court
Okay.
on. So if the issue decides in favor of the defendants,
So you are not willing to pursue this petition?
Lordship may close this with the observation.
Okay.
Because
Yes, Mr. Ahmed. Or Mr. A. Borua, learned counsel for the petitioner, Mr. Ahmed, learned counsel for the respondent. The learned counsel for the petitioner submits that the point raised in this petition, on the point raised in this petition, the learned trial court has already framed an issue.
Yes. Right.
And in that view of the matter, the petitioner is not willing to pursue this petition, and he submits that the petition may be closed. Mr. Ahmed, learned counsel for the respondent, submits that he has no objection. Accordingly, taking note of submission of learned counsel for both the parties, this CRPIO number 35 of 2023 stands closed.
Right.
Okay, hearing, I can hear.
Wrong teacher has came up. Wrong teacher has, it can appear wrong significant came across.
Wrong case.
Wrong teacher. My court record has been wrongly given. It should be 144. NDPS 144, 124 has came up.
Okay. The order to order noted. It should have been 144.
And the PS case is also wrong. PS case number, it should be 499. And GR case number is 3580.
Kaline PS case number
499. So, of the 2023 lawsuit.
it will GR PS case number. Heard, Mr. Learned counsel for the petitioner and Mr. Das, learned additional PP for the state respondent. Mr. Das pointed out that in the order dated 4/9/2026, while mentioning the number of the Kaline PS and also the NDPS case, some clerical mistake had occurred, for which a wrong PS case number has been called for. And as such, he submits that raised may be directed to call for the record of Kaline PS case number 499 of 2023 corresponding to GR case number 3588 of 2023 and corresponding to NDPS case number 144 of 2024 under section 20C of the NDPS Act. In view of the submission of Mr. Das, learned counsel for the learned additional PP, it is provided that recess shall call for the record of Kaline PS case number 499 of 2023 corresponding to GR case number 3588 of 2023 and corresponding to NDPS case number 144 of 2024 under section 123. No, under section 23C of the NDPS Act from the Court of Learned, where it is pending now?
Additional session judge lordship.
From the Court of Learned Additional Session Judge number 3.
3 Kasar.
Kasar Silsor, and it is further provided that in the order dated 9/3/2026, the Kaline PS case number 3588 of 2023 corresponding to GR case number 3588 2023 arising out of NDPS case number 124 of 2024 shall henceforth be read as Kaline PS case number 499 of 2023 corresponding to GR case number 3588 of 2023 corresponding to NDPS case number 144 of 2024 under section 20C of the NDPS Act. SSL list the matter after vacation.
Pending item 70 for motion. Orders.
May it please your lordship, my lord, this is a transfer matter, my lord. Transfer of a divorce proceeding instituted by the husband in Lakhimpur, my lord. On last occasion, if lordship can see the last order of the last date, it was listed, my lord. You were asked to take the justice service and the interim order for stay of the further proceeding was to be considered today. We went there to serve the notice, but they refused it. To that effect, we have filed an affidavit. And the lordships comes to the transfer petition, my lord.
Page number.
Pardon, my lord.
Page number.
My lord, in transfer petition, my lord, page annexure 9, page 1, my lord. Annexure 1, page 9. It was filed under the Special Marriage Act, section 27(1) and B.
Has filed an affidavit. And he submits that the petitioner, the respondent herein has refused to accept the notice. Then in that view of the matter, service deemed to have been completed upon the sole respondent. And he also submits that the interim pair of the petitioner be considered. And the next date is fixed on 28th of April. Accordingly, taking note of the submission of learned counsel for the petitioner, it is provided that the registrar lays the matter on 6th of April, and on that day, an endeavor will be made to finally hear and dispose of the petition.
Man, bibliography.
Pending item 21.
Please, my lord. This I was filed in connection the connected RSA
As official admitted on 22nd on the substantial question of law, my lord. The admission order is my lord. The also heard Mr. K. Sharma is present for the appellant and Mr. K. Bhattacharjee learned government advocate is present for the respondent number 4 and 6. The regular second appeal has been preferred under section of 100 of the Code of Civil Procedure 1908 against the impugned judgment in Dick dated 25/11/2025 passed by the learned civil judge senior division Sunitpur Texpur in title number 13/2024 setting aside the judgment in Dick dated 26/2024 passed by the learned civil judge junior division and in title suit number 109 of 2016 arising out of the title suit number 30 of 34 of 2016. The second appeal is admitted on the following substantial question of law, my lord. Whether the learned first appellate court committed a substantial error of law in refusing to act upon the registered sales deed exhibit 5 solely on the ground of undervaluation.
Whether any execution case has been filed?
My lord,
Execution
execution is not yet filed, but
Not yet filed. Okay, let notice go then.
because they are waiting for the appeal period. They are waiting for the appeal period, but the appeal
Maybe,
period is not this. So
We'll take this matter with the RSA. Let notice go at this SS. Heard Mr. K. Sharma, learned counsel
No,
for
my
the
lord, when the
applicant.
appeal is admitted on substantial question of law, that the
And
decree is to be
application,
stayed
this application
because the
under
in order 41 hearing,
order
notice is not
41
required to be
rule
issued, my lord. Notice is to
Five.
be issued only for the final hearing, my lord. The
read with section
principle is
151
to
of
be
the
stayed.
Code of Civil Procedure is preferred by the applicant for staying operation and execution of the impugned judgment and decree dated 25/11/2025 passed by the learned civil judge senior division Sonitpur in title appeal number 13 of 2024, whereby the learned first appellate court has allowed the appeal by setting aside the judgment and decree dated 28/6/2024 passed by the learned civil judge junior division number 1 Tazpur in title suit number 109 of 2016 and also directed cancellation of registration. The cancellation of registered sale deed number 701 of 2014 and the consequent mutation struck municipal entries standing in the name of the appellant.
I'm waiting for response. They don't have.
They are pro forma respondent here. They are supporting our case.
Mr. Bhattacharjee for respondent number 4, 5, and 6. 4, 5, and 6. Let notice be issued to the respondent, returnable in 4 weeks, and step be taken by speed post and also by usual process within your from today. Rest shall take this IA along with RSA number 23 of 2026. List after 4 weeks.
For getting under order, what more? Number 9.
Lordship, kindly pass over the matter for time being.
Comes for hearing, item number 22, Partner matter.
But on the last occasion, this honorable court asked the parties to file the translated copy of the exhibit 1. That we have. Hearing is already completed.
Translated copy of
Translated copy of the deed number 2095/2007, exhibit 1.
You have submitted it?
No, not yet, Lordship. Have submitted. We have given a judgment also along with it. Lordship, will like to hear the matter again, or otherwise hearing is completed?
No, on that day, hearing was completed.
Lordship,
So where is the question of again reopening it?
Lordship.
Heard Mr. Bhagavati, learned counsel for the appellant, Mr. PCD, learned counsel for the respondent.
My lord, I have to give some judgment, my lord. My lord, hearing completed, whether hearing is completed, my lord.
Yes.
My lord, I have to submit something, my lord, because my submission was.
No. On the other day, there was only direction to produce before this court translated copy of Exhibit 1.
Exhibit 1.
You have furnished it.
Yes, my lord. Along with the my lord, note, I have given the calculation of the limitation,
Yes.
my lord. And my lord, on merits, my lord, I have to submit some decisions of this Supreme Court as well as the Supreme Court, my lord.
No. On the other day, you have completed your argument.
No, I have not completed. Because only exhibit argument was only on the limitation ground, that is exhibit 1. Exhibit 1. The exhibit 1, my lord, my learned friend have submitted that limitation is starting from the refusal of the contract. My lord. But here is Article 54, here date is specifically fixed. So limitation is to be calculated from the date fixed in that exhibit. I have given also a citation, some citations in my note. Translated copy as well as the calculation of limitation. I have given some citations. That citation, my lord, I have to submit. It's not a good score.
Okay. We'll resume after 5 minutes. So, no,
Limitation-
Mr. Day, you see, your case is actually distinguishable from this case.
No, my law, interpretation of law, my lord. Kindly bear with
No,
me, my lord.
you say,
Interpretation of
in
Article 54.
in your agreement, 2 dates are there.
Yes, my lord. 2 days on what sense? One is to be performed by the second party, and second one is to be performed by the first party. If the first, so kindly say again, my lord. What is 2 dates? 2 dates, what it means? My lord, kindly see. Yes, my lord, kindly see the condition, my lord. Second party has to have the option to return the advance money within 30th. This is one date, my lord. 30th, that is 18/10/2007. Advance money taken by the second party. If he returned to the first party within 18/10/2007, then matter is there. This is one date. Matter is there. Because he will be bear his land and I will take the money. First party will take the money. This is one part, my lord. Second part, can you say, my lord? If he fails, to return the advance money, what will happen, my lord? This is the second conditions come.
Usually in the agreement, only one date is there. One date.
One date, that means, my lord, 30th post, that is
Hmm.
the limitation.
Mm,
Last date to perform the agreement.
mm.
Last date.
No, Mr.
No,
Day, you say
it's the second post of
two dates are there. And now you are contending that
No,
your
this is
cause
the
of action
condition-
arises
this is
from
the
the
condition
second,
precedent, my lord.
from the,
Two conditions are there.
Hmm.
First one, within Ashin, 30th Ashin, I have given the money, if you return the money within 30th Ashin, the agreement is there.
Hmm.
This is one condition.
Mm,
Second condition, if second party did not pay
mm,
the advance amount
mm,
taken from the first party,
Mm.
then he has given the time.
mm,
Then up to 30th post, you are given the 30th post is given because I have given my advance money and the remaining money I have to pay.
mm.
If he second party fail, then I have to perform my duty. What is that duty, my lord? I have to pay the remaining balance amount to him
Mm.
within 30th post.
Mm.
So I have, after he break the condition, I have offered. Then you take the balance amount and register the sale date.
Mm.
So limitation is given, my lord, to perform the register the sale with or
Mm.
take accepted the amount
Mm.
30th post. 30th post, I have to give the return the money or he has to accept the money and if he refused, then he has to register the sale date.
Mm.
If he is not accepted the balance amount within 30th post, this is the second condition, my lord.
Mm.
It is my responsibility to pay him within 30th post the balance amount.
Mm.
If I pay,
Mm.
then he has to accept it. And by accepting that amount, he has to execute the sale deed.
Mm.
This is the condition, my lord.
Mm.
So up to 30th post, he has the time to execute the sale deed in favor of me.
Mm.
If he fail, then I have the cause of action arise. I have to go to the court. What option I have, my lord?
Mm.
If he refused to accept the money within 30th
No,
post,
you
or
tell
not
me
registering
whether in all the agreements for specific performance of the contract, two dates are mentioned.
my lord, it depends on the agreement. It depends on the agreement.
Mm.
Terms and conditions should be followed, both the
Mm.
parties.
Mm.
Otherwise, give rise cause of action.
Mm.
And if the date is fixed, then limitation is to be calculated from the fixed date.
Mm.
And if no date is fixed,
No,
then
that's all right.
notice is to be given
There
from the
are
date of refusal.
in your agreement
Limitation
there are
start.
two dates, and you are conveniently taking the plea that your cause of action arises from such a date.
Yes. This is the law, my lord.
Mm.
My lord, interpretation, Article 54.
Mm.
This gives the period of limitation,
Mm.
3 years.
Mm.
From which period? There are two conditions.
Mm.
Number one, if the date is fixed, limitation is to be calculated from the date fixed.
Mm.
If no date is fixed,
Mm.
then notice is to be given. If he refused,
Mm.
then limitation will be start from refusal.
Mm.
This is the two conditions, my lord. Article 54.
Mm.
And that is discussed in this case, my lord.
Mm.
That is discussed. Can we see next paragraph 20?
Mm. Okay.
That quite independently and without a reference to the aforesaid decisions, another event, so and so came to that a mere reading of Article 54 would show that if the date is fixed for the performance of the agreement, then non-compliance of the agreement on the date would give a cause of action to file a suit for a specific performance within 3 years from the date so fixed.
Mm.
So, my lord, in my case, date is fixed. So limitation starts from that date, last date,
Mm.
to perform the agreement.
Mm.
If we break, that is the date, my lord. And in my case, it is the date that is 15th January 2000 and 2008.
Mm.
Starting from 15th 1 2008, my lord, limitation 3 years. So it comes to 14th 1 2011.
Mm.
And I have the suit is filed on 8/11/2010.
Mm.
Last date is 14th 1 2011, and suit is filed 8/11/2010. So well ahead of expiry of the limitation, my lord.
Mm.
Question of barred by limitation does not arise in this case, my lord.
Mm. Okay,
Lordship, only one clarification.
My lord, I have another question.
let him come.
Lordship,
You will give a chance. I will give a chance to you.
Lordship.
Yes.
Another decision. That is, my lord. 2015 5 SCC 223.
Mm.
Ratnavati versus Kobita Dhanasham Das. Paragraph 48 and 49.
Mm.
Same thing, my lord, as earlier decision, which also has Article 54. Article 54 of the Limitation Act, it is quoted. Then, my lord, 49, paragraph 49. Mayor's reading of Article 54 of the Limitation Act would show that if the date is fixed for performance of the agreement, then the non-compliance of the agreement on the date would give a cause of action to file suit for a specific performance within 3 years from the date so fixed. So, my lord, it is clear, my lord. From the date fixed, 3 years.
Okay. And the other judgment?
Other judgment, my lord.
Same thing.
Ram Kumar, Usha Devi.
Mm.
Usha Devi versus Ram Kumar Singh.
Mm.
Paragraph 8 and 9.
Mm.
My lord, paragraph 8 stated the limitation, my lord, Article 54.
Mm.
Then paragraph 9. Coming to the facts of the present case, we find that in the agreement dated 17/12/1989, it is specifically mentioned that the sale deed would be executed within 1 month from the date of the sale agreement. The period of 1 month would expire on 16/1/1990. And once there is a specific date fixed for performance, the limitation period would be 3 years from the said date, which would expire on 16/1/1993. So, my lord, from the date fixed, this to be calculated. That is my humble submission, my lord. If the law says that, my lord, if date is fixed in the agreement, the limitation starts from the non-performance of the agreement from the date. So cause of action arises from that date.
No, the problem is that in your case, in your agreement, there are 2 dates.
2 dates, my lord, kindly see.
Mm.
Your worship, correct. 2 dates is there.
Mm.
One date is, my lord, one date, first date is to be performed by the vendor second party. Because he has taken the money 95,000 on condition that if he paid 30 tashin to the first party, purchaser, then matter ends there. Matter ends there. Advance money return, one. Now, the second person, my lord. If he fail, then the condition is that the first party has to deposit the remaining amount, balance amount. Remaining balance amount he has to deposit within 30 force, my lord. So that is the date, my lord. second person, first person, he has not complied with second party.
Mm.
Next, second person comes. But it is the duty of the first party to pay the balance amount.
No,
The
you
second
see, had the second date not been there,
My
then
lord.
had the second date not been there,
Not, it is clear, my lord, Second 30th post.
no. Had it not been there,
Yes.
the limitation would
If it
start
is
from
not
the
there,
first date.
Then specific purpose does not arise, my lord. It will be go to the break of first person. Condition agreement should be read as a whole, my lord. Up person, second person, that is not as a whole what is said, my lord.
Hmm.
Terms and condition is to be read in full.
Mm.
First condition, second condition, whatever conditions are there, it will be
Okay.
written,
Okay,
my lord.
okay, all right.
Cannot be separated from each other, my lord.
Mhm. Yes, Mr. Bhagavati.
Lordship, he cannot approbate and reprobate. Approbate is the 30th sin. Actually, dates he has given wrongly. I have given the Google this thing as well, Panjika also. It is not 15. 18, he says 18, it is 15.
Mm.
Lordship, approbate is that he said the second condition comes into play in this case. Second condition, he himself has evaded. He himself has disregarded because by issuing the exhibit 2, in exhibit 2, he has clearly told that first of Kartik, the first of Kartik again comes to, that is 1910-2007.
Mm.
The limitation that means on that day we refused. The cause of action starts on that day, 1910-2007.
Mm.
So he can file a suit from 2010-2007 till 21-10-2010.
Where is the exhibit 2?
Exhibit 2 is that
The file.
exhibit in the file. That is a demand notice. He did not disregard that demand notice. Demand notice is very rare, very much.
Read the agreement first.
Agreement will not agreement he himself has evaded. Second clause he has himself evaded. He cannot say approbate that yes, I like to go. Now he himself has said by issuing demand notice. At page 2, 3 conditions. That on from the first day of Kartik, 1414 Bengali era, my client approached you many times. That means he approached me on
Many times, yes. From first Kartik to
First
30th post, I have the right to approach. Because
Mr.
this is the
Dave,
limitation,
please,
my lord.
please sit down.
he approached, first date was 1910-2007.
Mm.
That is first day of Kartik. On that day we refused it. Let us not read anything more. Let us not read this. So by these conditions, by this,
In exhibit 2, where it is mentioned?
it is at page 2. That is your para number 3.
Paragraph number 3.
That on and from first day of Kartik,
Mm.
1414 Bengali era, my said client approached you many times to accept the rest and final amount of rupees 1,29,000 and requested you to execute the final sale deed as per terms and conditions of the said agreement. But you every time have refused to do so. That means we refused on the date of 1910-2007. Refused. So when we refused,
Will not come, my lord.
then specific performance will come. Cause of action starts from that day. So cause of action starts from that day. He could have filed the suit from
So,
1910.
yes, Mr. Bhagavati, this first day of Kartik 14,
It is equivalent to
1914.
1910. 1910-2007
1910-2007.
as per Panjika and Google Map. Google
2007.
7. So by this demand notice, the second clause of the agreement, he disproved it. He disregarded the second clause. Therefore, he now cannot say, he cannot approve it that I like to come second clause. So second clause, he by his action, by her action, herself said, "No, I will not go to second clause because by the demand notice." So refusal comes on 1910-2007. Therefore, she could have filed a suit from 2010-2007 till 21-10-2010, 3 years. So here the 18 days comes. Delay was 18 days. So it is by this.
So, according to you, if we count the limitation from this date, that is
Yes.
19/10/2007,
7,
there is delay of 18 days.
18 days. Because the suit was filed on 8/11/2010.
Mm. Mm.
Lordship, my second line of argument, this is actually barred by limitation, everything goes. Even as an utmost caution, I have taken second line of argument is that specific relief of Act 1962 was amended
Mm.
by Act of 18. Act of 18.
Mm.
Act of 18 was amended in the year 2018.
Mm.
As the suit governs prior to the Act of 18, therefore the suit is governed by 2000 before amendment. It is not retrospective, it is prospective. So under section 16, under section 20 of the said act, new act, old act,
Mm.
that means the court has the power, honorable court has the power to give this one alternate relief. In the suit prior to amendment of 2018, the plaintiff has to pray for alternative relief. In the event specific performance cannot be enforced, alternate relief praying for advance amount together with the interest.
Mm.
Amendment before the amendment of 2018. In this case, the honorable court could have allowed us, could have granted us that alternate relief also, because in this case presently in the sea, the plaintiff would not suffer anyway. Plaintiff has already taken one plot of my land by on the same day. A second plot of land by this agreement, she wants to take my second plot of only plot of land where I have been living with my families. And as in the case, it is already seen that we have been living there, because by their own petitions, it is clear that we have been living there since long. So therefore, my second submission comes that I am protected by old act of 2000, the specific relief act 2018, prior to 2018, because that 2018 act is a prospective, not in retrospective. So section 20 of the specific relief act, I am protected. Alternate relief could have been given, and alternate relief I have given certain rulings before of the honorable court.
Mm.
Court will look into it.
Mm.
Third is that that dates he has shown is not correct, because already I have given the authentic report, authentic document is there. Court will rely upon that documents. That is Panjika as well as Google dates.
My lord, regarding my lord second submission, my lord, regarding discretionary power, exercise of discretionary power, my lord.
Mm.
No substantial question has been framed in this regard, my lord.
Any other substantial question already framed?
Only
Any other substantial?
two substantial questions to have framed before by this honorable court.
Mm.
Number one, whether the court below was correct in applying the discretion for decreeing the suit for specific performance of contract on the face of stipulations made in the exhibit 1, alleged agreement for sale. And number two, limitation. My lord, there was no substantial question framed for discretionary exercise of discretionary power. And moreover, my lord, if landed friend argued that I beg to submit, my lord, regarding discretionary power, my lord, some decisions, my lord, and also when it can be exercised and how to exercise, my lord.
Actually, by order dated 9/1/2025, this honorable court has framed that limitation issue.
Yes.
And as well as Mr. Bhagavati submits that he may be granted some time to reply to the additional substantial question of law. This is actually, and that original substantial question law, any other substantial question.
One substantial question of law.
And addition.
During the argument, my lord, Another substantial question was framed, that is limitation. No substantial question.
Lordship,
other than-
I'll leave it to your conscience. Whether that second point comes, because law is the law, after all a law. After a law, a discretionary power court can at any time exercise it.
But regarding discretionary power, my lord, I have some decisions, my lord.
Okay, all right, you furnish it to the court.
My lord.
Mr. Heard, Mr. Bhagavati, learned counsel for the appellant. Mr. PCD, learned counsel for the
I saw the
respondent.
concurrent findings file regarding, I have submitted decisions.
Argument concluded. Judgment reserved.
Lordship.
Number 23.
Yeah, my lord, this case is regarding this partition, my lord. This partition suit was filed by this plaintiff, and this is allowed, and title of allowed. The RSA is by defendant. Is considering that this is already partition, second partition is barred. So, my lord, it's substantial question of law, my lord. Here, if we go to this exhibited documents, my lord, crux of the matter is that, my lord, the Indranath Hazarika, who is the owner of the several properties, Gauhati, Shillong, Jorhat, Shivsagar, and he has 3 legal heirs, son, daughter, and wife. So, when wife died, my lord, when Indranath Hazarika died in 1965, in 67, the appellant has mutated his name against the Gauhati property. And in 1974, his daughter has mutated her name in Shillong property. They are in peaceful possession. They till 90. In 90, what happened, my lord? The respondent, the plaintiff, was as a tenant. She was in a tenant in the property of Gauhati, and she was asked to vacate. Then she claimed that she has the 50% share in the Gauhati property, and partition suit was filed. So, claiming is as a joint property. From LCR, so my here only, my lord, my submission is that 2 submission. One is the partition is oral by oral partition. They have settled 2 property of Shillong, property of Gauhati. Gauhati property in share of this appellant, and Shillong property, the respondent plaintiff. That is was 27 years or from 67 to 90, they have not dispute. The revenue entries are there, they are paying revenue, everything is there. But in 90, there is a dispute. Dispute because the Shillong property want to sell by the respondent plaintiff, but this was opposed, then this is the partition suit here. But so here, my only argument is that when oral partition is acted upon and it is continuous, it attains the finality after so many years, how the second partition suit is filed. And secondly,
No, Borua, you come to this substantial question of law.
yes, my lord.
First one is shifting of burden of proof on the appellant
Yes,
of the claim of the respondent plaintiff that she is the absolute owner of the suit property at Shillong.
yes.
So burden of proof lies upon whom?
She in a Shillong property, there is a suit and the court declared that she is the absolute buyer of family settlement. She has name is muted. In Guwahati, she said that this is a joint property. That is her purpose. Now this land trial court says that why we have edited in Shillong, we one partition in Shillong, that we disown our jointness. That is the adverse findings against us. Now, my here contention is that from the revenue records, from the conduct, it is settled that she is settled with that Shillong property, 1 bigha in prime place, and son, his brother, is settled with the in Guwahati, so 1 bigha of land. Now, after so many years of settlement, how can she one partition? Whether it is barred by after 12 years, it's barred by law of limitation. Secondly, my lord, if I go through this executed documents, it shows that 67.
No,
mutation
we are
was-
not concerned with the limitation here.
Yes.
We are concerned only with the substantial question of law framed by this court at the time of admission of this appeal.
My lord.
First one is a burden of proof.
Yes, my lord. So here, my lord, in Shillong also, in case.
How you have established that you were the owner of the suit property?
Yes, my lord. My lord, there are documents, if we go through these plaintiff's documents, my lord, LCR, exhibit 2 is the mutation is granted, my lord. Then in Shillong property, all exhibited shows that go, my lord, exhibit 5 of this plaintiff.
You are referring to exhibit
5, my lord.
Exhibit 5 of the plaintiff.
Yes, my lord. First plaintiff, then defendant's exhibit I am
No,
showing.
here the exhibits are exhibited as marked as exhibit A, B.
That is the defendant's. Yes, I am sorry, my lord. The plaintiff's exhibit I am referring. My lord. First. But let us go to this defendant's exhibit. Okay. Exhibit A is the building permission, my lord. This plaintiff under suit land, plaintiff has obtained this building permission, my lord. It shows that he is in possession. Not only that, he has the mutation over this land. And way back in
Exhibit,
1967.
you are referring to exhibit?
A is the building permission.
No, in the plaintiff's exhibit.
Yes, yes. Plaintiff's exhibit now, my lord. Yes. Plaintiff exhibit is kindly see, my lord. Exhibit number, my lord, 5. Exhibit number 4 shows that the plaintiff was the tenant, and that is why the notice was served to them that you vacate this premises, and she filed a suit for partition. That is the cause of action in 90, my lord. But way back in 1967, whole land was mutated in favor of the appellant. And it is also knowledge of this, my lord, the plaintiff. So the plaintiff has exhibited exhibit 5. Here shows that Chandan Hazarika, his name is mutated on possession, and my lord, they relinquish her portion in lieu of the Shillong property, my lord. So 67, my lord, this is the chitha.
No, admittedly, there is no family settlement deed.
Oral, my lord, that is the reason. So oral settlement.
Mhm.
Orally it is settled, but my submission is acted upon. It is acted upon, it is continued for 27 years. Now 90 they have hesitated that there should be party. Joint property, the she should also share upon it. Now, my lord, exhibit 5 and 6 shows that the Chandan Hazarika, his name is mutation. Mutation, my lord.
Exhibit?
Exhibit 5, my lord, 5 and 6. This is regarding Gauhati property, my lord. Chandan Hazarika.
Mutated.
Yes, my lord. Then, my lord,
Is there any Jamabandi copy here? No.
my lord, this is Ulugari Moujar, Terasmedi Maniman Potter, Jamabandi Sakurita Nakal. This is the executed document. This is Jamabandi.
So, if you can produce the copy of Jamabandi, then we can see from there how the name of Sri Sandan Hazarika was mutated there
My lord.
because of the remark column.
Yes, my lord. My lord, actually, we have also exhibited exhibit D, my lord. Exhibit or D means in defense, defendant has exhibited one, my lord, mutation order passed by this ASO, my lord. Then
Exhibit D.
D, my lord. Exhibit. Exhibit D, my lord. This is the order of in ASO Guwahati, 22/6/1967, my lord. His name is mutated against the whole portion of Guwahati land, 1 bigha in 67. Then exhibit E, my lord. His entry is made in the revenue records, and F is paid the revenue so many years. And building permission was obtained in his name. Most importantly, my lord, the land is mortgaged, and they have given, the plaintiff has given no objection, admitting that this she has relinquished his portion in lieu of this Shillong. When UCO Bank in 1971, the bankers called upon both the parties to about clearing whether land may be mortgaged in the name of this plaintiff, defendant. Then from C, they have declared that they have no objection, and meaning thereby that she has the positive knowledge that this is the exclusive position of the defendant. now 71 and 91, my lord. After 20 years, whether she is allowed to file the partition suit claiming the 50% share of this land. More so when is given the absolute share in Shillong property. So in Shillong case, as well as her pleadings also there, the Shillong is her absolute property, he relinquished. If the Shillong property is relinquished, so why not she relinquish Gauhati property? So one party how can get whole of the other share and 50% of that share? That is a substantial question
The
of law.
problem is that
Well, here my
there is no written agreement
written agreement
or
is not-
written family settlement.
Yes, my lord, that is oral settlement. Only my contention here is that the conduct, the executed documents, revenue entries, all this goes to shows that she has relinquished Gauhati property, and now after 27 years, she wants partition. My lord, that a substantial question of law, my lord, probably not framed. I have raised it at now, my lord. Because lords, at that point, that question may be, my lord, is vital because there is lot
No,
of
the question is whether any such plea was taken before the trial court and the
No.
first appellate court.
Comment. I will put on the controversies. These are brothers and sisters. The plaintiff and defendant are brothers and sisters. These are properties owned by the parents, the late parents. Now the parents have three properties. One in Gauhati, one in Sipsagar, one in Shillong.
and Jorhat also. So all property.
All properties. Now, what they say is, now as far as this property, some of the properties are sold, the proceeds are distributed among the heirs. Now this Gauhati property remains. I filed the suit saying that I am entitled to half of the Gauhati property and therefore I sought partition. In this suit, for the first time, they came up with a defense, not in the original written statement, but in the amended written statement, saying that no, there was a family arrangement under which you relinquished your right over the Gauhati property and you got a Shillong property. This is what the case they come up with in the suit in the amended WS. The trial court as well as the first appellate court come to a finding that is two allegations. The first allegation of an alleged family settlement and the second allegation of relinquishment of right were not proved. And in fact, from his own WS, I will show that he himself has not agreed or not accepted to relinquishment or a family settlement. So this family settlement was something which was just orally pleaded. It is not part of the pleading. So both the courts below were rightly
No, no. Is it not mentioned in the pleading?
No. There is no whisper of a family settlement in the amended written statement. He merely says that the defendant, that the plaintiff offered to relinquish half of her share in the Gauhati property upon the defendant agreeing to relinquish his share in the Shillong property. However, the defendant refuses to relinquish his share in the Shillong property. I'll show the pleading. Let him read it. But there is no whisper, there is no pleading, there is no evidence laid regarding a family settlement. There is no evidence laid regarding to any relinquishment of right. So accordingly, the trial court as well as the first appellate court came to a conclusion that the family settlement or this relinquishment was never established. Based on which these questions of law were framed. And an additional question of law was framed, whether while partitioning the suit, the court should have followed Order 26, Rule 13, which also I'll address when my turn comes. Because there is a preliminary decree of partition, whether a commissioner was required to be appointed under 2613. So these are the three questions of law, and that is where we stand today.
No. From the order dated 14/10/2014, only two substantial.
Yes, then
questions-
subsequently by an order of 1/6, my lord will find an order of
Yes.
1/6,
Mm.
2022.
Yes, got it.
Whether the court below justifies passing a preliminary decree without taking recourse to 2613. So the issue at hand is very simple. These are brothers and sisters. This is their parents' property. I am saying that being the daughter, I am entitled to half share in this property and therefore I sought partition. That was the suit. The suit was as simple as that. To which, in the amended written statement, the defense came of family settlement, which the courts below have said, there are concurrent findings where the court below says that this is not established. There are detailed findings which I will show from the trial court.
Actually, my lord, Exhibit 11, the Shillong's order, that reflects that when the petitioner, the appellant is the plaintiff there, the Shillong court says that there is a family settlement as per pleadings of the defendant. So on that count, my lord, this family settlements concept comes to Shillong. That is why I said that they have signed a mutation. Mutation was not never challenged. So you are acted upon. That is why Shillong property is decreed in
No,
her favor.
never challenge doesn't mean that they have acted upon.
Acted upon because 73 the mutation was granted and it was challenged in 90. So that was the findings of Shillong court that it's a family settlement. It is absolutely in the share of the daughter. That is we are executed, and that this Shillong judgment also discussed in trial court. Trial court only says that when you think yourself that it is in your share, why you file suit in Shillong? So you disowned your own concept. That is the findings of the trial court. Because burden of proof, onus of proof comes there. So whether joint or whether separate, my lord. In that way, it was, my lord.
So dispute is only regarding the Gauhati land.
Gauhati land, my lord. Whether it is a joint property or it is a already partition, and that partition may be oral. In Shillong, there is no agreement, no oral written documents, but oral and acted upon on that count, on that Shillong is decreed. In Gauhati, of the same, because in Gauhati, 67 mutation was granted, permission was taken, loan was taken. They are also present. They give no objection. So they have acknowledged that it is whole shares falls upon him. Now, oral, my lord, partition, if acted upon for a long period of time, can they now challenge this table?
When no objection was given?
My lord, when 1971, and my lord, when loan is
No
taken.
objection for obtaining loan.
Loan. So they have also gone through this. Now they said that.
No, if the right is relinquished, right was relinquished, then where is the question of obtaining no objection certificate?
No objection because mutation, when mutation documents, Jamabandi is placed before the bank, then bank go through this scrutiny, says that originally his father's name, the patta was there. So that is why other legal or NOK on next of kin certificate, other legals are called for, and they clarified, and then took the sign of the other legal heirs, and loan is granted. My lord, so my lord, may I pray, my lord, here? Get it.
So now what is your fourth substantial question of law?
My lord, whether oral partition is acted upon and whether suit was time barred because of that.
No, the question is whether such a plea was taken in the pleadings.
Kindly tell look at para 7 of the written statement, page 22 of the article. Page 22 of the in written statement, such as page 20 and 22 para 7. May I read?
Yes.
That as regards the statement made by the plaintiff in para 7 of the plaintiff is stated in the defense of the absolute owner of the article and landlord position that the entire group of because plaintiff has no right and interest of possession of this building. The said act was has been within the name of the defendant in 1967 with no notice to the plaintiff and the plaintiff consented to such request allow her to sell the property of their father at Shillong, but the defendant did not agree to such proposal, giving up his claim in respect of Shillong properties. Now, the defendant reserves his rights to claim title and possession of the properties left by late so and so at Shillong, which is in possession of the plaintiff, as the defendant claimed possession of the properties at Shillong to the plaintiff in order to counterblast his claim, filed his fictitious false to the defendant reserves his rights to claim and recover possession of Shillong properties from the plaintiff. The defendant, being the absolute owner of the property, has right to get the mutation in his name. So if he is saying that I gave you Shillong, family settlement was that you got Shillong property, I got Gauhati property. He himself says that Shillong property he is not going to give up his rights. That is one. Now please see the amended statement at page 24. 14A. This is the amended W.
14?
14A.
Hmm.
Small a. Definitive. This is the new case.
Hmm.
Definitive has relinquished the entire claim over the Gauhati property in favor of the defendant in lieu of movable property, including ornaments, cash in hand, and half share of Shillong property and Srinagar property left by their parents, and as such also cannot claim partition over Gauhati property, and the suit is liable to be dismissed. So this is the only period. There is no family settlement. First, in the original written statement, he said that I am not going to give away my right over the Shillong property. That's a joint property. But you have no right over Gauhati property. That is what he says in para 7. In para 7, he says that Gauhati property, I am the sole owner. Shillong property, I am half owner with you. So I am not going to give you Shillong property absolutely. So he acknowledges that's the joint property. Then an amended claim, he says that you have relinquished your right in the Gauhati property, and that's why you got half a right in the Shillong property. Now, as far as I am concerned, my suit was very simple. My suit said that as far as the Gauhati property is concerned, I am entitled to half share as I am the total. The written statement does not say that there was a family settlement of 1964 or whenever, as per which mutation was done, to which I consented, loan was taken, to which I consented. And anyway, mutation, jawabandi, is anyway revenue record does not clear established title. Title will have to go saying it's the Hindu son, daughter who inherit the property as per the succession. Now these are the only two heirs, so they get half. All that I am saying is that I am entitled to half of all the property which was owned by my parents. So this entire claim of written of family settlement or relinquishment was never cleared before the trial court. No evidence was laid. The trial court only made one error by saying that the family settlement was not even written or was not even registered. That may run counter to Kale. But the appellate court clarifies that, saying that there is no, the family settlement has not even been established. It's not even pleaded. And today at this stage, you want to have a substantive question of law whether the family settlement was there and whether this suit for partition is barred in light of that family settlement. But the family settlement, pleading of family settlement never existed before the court's below.
My lord, Shillong case, my lord, exhibit, my lord, 11, but it's very not legible, my lord, in LCR. And here it is discussed. The family settlement concept is brought by them only to claim the whole of the Shillong property. My lord, page 3 of the LCR, my lord, exhibit 11. Page 3, my lord. That the Srimati
Exhibit?
Exhibit 11, my lord. They also rely on the Shillong, my lord, case. Shillong case, they have themselves pleaded that it is a family settlement. By family settlement, she has entitled the whole share. Page 3. Property in question was transferred to OP. My lord, it is handwritten and a certified copy is given like that only. The type copy is not there. The suit property in question was transferred to OP in 1974 by transferring the name from Sanders on to. On the basis of family settlement.
It is not legible.
Not legible, my lord. If
Can I, do you have any translated, type copy?
Today, my lord, if I am given some time, I can place it, my lord, and that day, my lord, this question I will argue, my lord, this. Yes.
On 90s holiday. Can it be on Tuesday?
I will try, my lord.
Not use the nine.
9th is holiday.
9 holiday, after Bihu, my lord, one date may be fixed. I also come with this. my lord,
Okay.
arguments.
Heard Mr. Borua, learned counsel for the appellant, and Mr. Your name, please?
K. Talukdar.
K. Talukdar, learned counsel for the respondent. Heard in part, leave
Yeah.
the matter on 23rd. On that day, learned counsel for the appellant shall produce before this court the typewritten copy of the exhibit 11.
My lord. Obliged.
Writing item 9.
May I please, Lordship? Lordship, kindly, matter may be adjourned for the day. My senior engaged counsel has left the court due to some personal difficulties. Release the matter after
Okay,
vacation.
miss, your name, please?
E. Devi.
E. Devi, learned counsel for the appellant. Submits that conducting counsel, Mr. K. Ahmed is,
Due to some personal difficulty, has left the court.
he left the court due to some personal difficulties, and as such, she pressed for listing the matter after vacation.
Vacation.
After vacation, parallel, this is a list the matter after vacation.
Obliged.
May I please, also, I take liberty. Can I the registry or this can do this because that would be more convenient of the.
No, no, it is
Okay,
your
I will,
case,
we
you do.
can.
Okay.
Item 24.
Please put this matter
Pardon?
at 2.
Okay.
There is no, my lord, subsequent documents cannot be introduced without the leave of the court. But my lord, this act, 1971 Act is a, my lord, special legislation. And my lord, if I may, my lord, just take paragraph 49 of the judgment, my lord, which I have,
No, that's all right. There is no doubt about it.
my lord. Since it is a special statute, my lord, and my humble submission is that, my lord, full opportunity should be given to both the sides to my lord, present their case. And my lord, unless the things come by way of pleadings, my lord.
You cannot like the state officer.
My lord.
You cannot file pleadings like the pleadings you have filed before the state officer.
No, no, before the state officer, my lord, we are the authorities who conduct the proceedings. The other party is the person who is liable to be evicted. We are the authorities who have been given power under Section 5 of the Act to conduct the proceedings. We issue notices, we call for the records, and if the authority is satisfied that there is no my lord, proper records available to show that he is the title holder and it is purely a railway land, we evict them. We pass an order of eviction. Against that order, my lord, now they have come in appeal. And my lord, we being the state officer, my lord, now we want to file by way of a written objection the entire details, whatever was is available with us. Now, since, my lord, Section 10, that is what my humble submission, my lord, is that we should be given full opportunity and to present it by way of pleadings. Otherwise, my lord, certain things may not be appreciated.
No, where is the question of filing pleadings before the appellate court?
My lord, that is why humble submission, there is not an appeal as that of CPC, my lord. Because if my lord take Section 10, although it is worded as appeals, my lord, Section 9, but one of the judge, it talks about an appellate officer, my lord. Now, the word is appellate officer, not although it is an appeal, my lord, and that officer, my lord, is the, my lord, as per the Supreme Court judgment, it's a district judge, my lord, who is the head of the, my lord, judiciary, district judiciary. The appeal lies to, my lord. So that this issue was, my lord, the judgment which I have cited, my lord, that issue came before the Supreme Court, my lord, whether it is
So,
the appellate officer is a persona designator or a civil court.
Civil court.
So that, my lord, finding Honorable Supreme
The
Court held.
civil court has the if as per this proposition, the district judge has to act as a civil court.
My lord, my lord.
And in that view of the matter, in the appeal,
My lord, if I may, my lord, read paragraph 49, my lord, for a moment of that judgment.
Which paragraph you were referring to here?
Paragraph 49, my lord. If I may read, my lord. The fact that there is no express indication in the 1971 Act about the procedure to be adopted or followed by the appellate officer, it would not follow therefrom that the district judge or the designated judicial officer who hears the appeals under section 9 does so not as a court but as a persona designator. For the reasons already alluded to, we have no hesitation in holding that the remedy of appeal under section 9 of before the appellate officer is not as persona designator but to a pre-existing judicial authority. In that case, the procedure for hearing of the appeals will be governed by the provisions under the 1971 Act and the rules framed thereunder, including the enactment under which the judicial authority has been created, such as Maharashtra Civil Courts Act and City Civil Courts Act. My lord, such a pre-existing judicial authority by implication would be bound to follow the procedure underlying the said enactments and also to observe the doctrine of fairness in affording opportunity. Since the edifice on which the conclusions reached by the Delhi High Court that an appellate officer is a persona designator not a civil court cannot be countenanced in law, the Bombay High Court decisions in Nulsi Neville Wadia case and Prakash Securities cannot hold the field to that extent for the same logic. And my lord, if I read section 9, the provisions relating to appeal 9.4, my lord, which I have read earlier, that clearly says after giving the parties opportunity of being heard. Now, opportunity of being heard, my lord, would include the right to file a written objection effectively, my lord. Otherwise, since section 10 gives, my lord, finality to the order, subsequently, my lord, the only remedy to challenge section 9 is, my lord, by filing 227. And
No,
as lordship
you
knows,
see,
my lord, 227
in
appreciation
CPC,
of evidence, my lord, cannot be done.
In the morning, I have told you that in CPC there is provision for filing cross objection and cross appeal.
Yes, my lord, but there is no provision for filing objection in appeal.
You can,
in CPC, I have checked, my lord, in appeal there is no
but
provision.
you can argue in support of the judgment or the order passed by the state officer.
My lord.
You see, there is one decision of Supreme Court, Ravinder Kumar Sharma versus State of Assam and others.
My lord.
Reported in 1999 7 SSC 435. Here, the Supreme Court has dealt with Order 41, Rule 22.
My lord.
And another decision is there.
No.
Bihar Supply Syndicate versus Asiatic Navigation, reported in 1993 to SSC, page number 639,
My lord.
where it is stated that Order 41, Rule 22 permits, as a general rule, respondent to prefer an objection directed only against the appellant.
My lord.
You see, you go through these two decisions,
My
and
lord.
another decision is there. Chaudhary Sahu versus State of Bihar,
My lord.
1982, 1 SSC 232. You examine these
My lord,
decisions
my
and
lord.
you come prepared on Monday
My lord.
whether this decision will help you or not.
My lord. My lord. I'll go
Heard
through.
Mr. Gupta, learned counsel for the petitioner. Place the matter on Monday for further consideration.
Oblige.
Item two.
Next time. Four.
2 to 4 same.
Up to 4.
Item number 24.
So the original suit was under the Assam Urban Area Land Control Act.
My lord,
Whether appeal will lie.
this is not applicable because it is outside the town area.
Pardon?
Outside town area.
Okay.
So it is admittedly, my lord, it is not a town land.
Okay.
So it doesn't apply. So,
Okay.
but trial court, my lord, here, especially, my lord, decided the suit in accordance with the Urban Land Control Act. Urban Land Control Act means, my lord, once a defaulter, always defaulter. So for 1 month also, if one is defaulted, he is liable to be evicted. He cannot. But in other cases, my lord, 114 is there, my lord, that at the time of hearing we can offer pardon. Definitely default is there. That is the, my lord, only question, my lord, on the basis of which, my lord, this appeal has been admitted. And if your lordship see, my lord, the trial court's judgment, they have applied, my lord, that Land Control Act. Trial court judgment, my lord, that starts at page 23, but I shall take your lordship, my lord, to page, my lord, 32. My lord, last paragraph. Yeah, my lord, yeah, issue number 3, my lord. Whether there is any default in payment of rent by the defendants to plaintiff. Now, last paragraph. I have heard the argument forwarded by parties. The learned counsel for a plaintiff contended that defendant is admittedly a defaulter in respect of a suit cases. Learned counsel for a plaintiff further contended that the defendant has not paid the rent under Assam Urban Area Land Control Act, hence the suit is liable to be declared. Well, that is their argument, madam. Now, the cause of action, madam, your lawsuit will see the third paragraph. In an instance suit, the plaintiff is admittedly the owner of the suit premises and the defendant is the tenant. Your lawsuit got it, my lord?
Page number?
That page, 33.
Okay.
33, my lord, the last but one paragraph. Instant suit. Your lawsuit got it, my lord? The plaintiff is admittedly the owner of the suit premises and defendant is the tenant. The plaintiff has alleged that defendant is defaulter in payment of rent and the suit premises is required for the purpose of defendant. As such, the plaintiff has the cause of action for his suit because defaulter in payment of rent is a ground of eviction tenant under Assam Urban Area Land Control Act. Now, my lord,
Whether the length is available here,
length, yes,
page number?
yes, it is there. My lord, length is available. My lord, it is that page. I'm just thinking. At page 5. The schedule premises is at page 15.
Hmm.
Here it is in Sapekati. Kothai Kunda Gaon.
So the that place is not covered under that act.
Land control act does not follow. I mean, that will be covered by TP Act, my lord.
By
TP Act. Transfer of Property Act.
TP Act.
So here, my lord, if you also see again, my lord, the judgment at page 37, my lord, the fourth paragraph. In this present suit in hand, the defendant failed to comply with the mandate of law as provided under section 5(4) of the Assam Urban and Control Act 1972. In absence of evidence by the defendant, he failed to discharge the burden that the defendant is not defaulted in payment of rent in order to get the protection under the aforesaid provision. In this present suit in hand, the defendant has not adduced any evidence in their support to establish the fact that rent has been paid regularly to plaintiff. So he has applied this Assam. Now, my lord, the appellate court has not uttered anything, my lord, about this finding. He has, my lord, just upheld it. My lord, that is why, my lord, the substantial question of
No, whether you have taken any plea before both the courts below.
Yes.
That this Urban Area Rent Control Act is not applicable.
My lord, that was I don't think, my lord, is taken. But whatever it may be, my lord. Whatever it may be, because law cannot be changed, my lord. Because when the rent control act is not applicable, plaintiff submitted, my lord, the court will not do it. Because I have a right, my lord, under section 414, my lord.
No, that's all right. You have a right.
So,
but you have submitted to the jurisdiction of the court. You have participated in the
proceeding. But under wrong law, my lord, if it is decreed, my lord, then this honorable court has the power, my lord, to remand the matter, to decide in accordance with law. Because
yes, Mr. Ali, what is your stand?
Lordship, my learned friend is confined to the judgment given by the Munshi. Here the order and the judgment and decree challenges the appellate court judgment. So your lordship knows very well, as soon as judgment and decree is pronounced by the appellate court, the judgment rendered by the trial court, it merges with the appellate court. Now, whether the appellate court has committed any illegality or irregularity or infirmity or any illegality. Now, your lordship, for the time being, it may be ignored that this judgment passed by the Munch, because that has merged with along with the appellate court. In the appellate court judgment, your lordship will find that this is a judgment, your lordship, under the Transfer of Property Act. No, reference of the Urban Rent Control Act, and your lordship will find whether it is under the Urban Rent Control Act or a Transfer of Property Act, your lordship. So, for the ingredients of defaulter is concerned, it is same. If is a defaulter under the Transfer of Property Act, is liable to be evicted. Same is the case with the Urban Rent Control Act. Also, your lordship is the defaulter. The consequence is that he is liable to be evicted. So, for the bona fide requirement is concerned, that is also same, your lordship. That means the courts below your lordship, whether it is Transfer of Property Act or Urban Rent Control, the court have the trial court as well as the appellate court has jurisdiction to pass the decree. There is no infirmity. Supposing there is little bit irregularity, your lordship, not infirmity, irregularity. that is hearable one your lordship under section 99 of the civil procedure code. That is there, your lordship. Now your lordship will come to the judgment and the judgment, your lordship, at page 42 of the appellate court. At page 42, your lordship. It is dated, your lordship. 22nd day of April 2019. Now, in the entire judgment, your lordship, there is no reference, no mention of any urbanized land control act. So that means, your lordship, the appellate court has not followed whatever has been stated by the trial court, your lordship. There is no whisper in the appellate court judgment, your lordship, that the honorable court has, the learned first appellate court has followed urbanized land control act. Rather, it has, it appears, your lordship, from the entire judgment, and that is regarding issue number whether there is any default on the part of the plaintiff, your lordship, whether the plaintiff is entitled to recovery of area rent and area rent, current rent, as well as from the dependent. So these are the two issues, your lordship. 3 and 4, your lordship, whether it is Transfer Property Act or a Urbanized Land Control Act. Same. He is a defaulter. This is a concurrent finding. Whatever may be the act, your lordship, he is a defaulter. This finding is, your lordship, it is concurrent. This is the defaulter. Whether it is under the Transfer Property Act or Urbanized Land Control Act, so far the area rent is concerned, I am entitled to get, your lordship, because he has not paid since 2009. Till date, your lordship, he has not is admitted. And I just say, your lordship, he has not adduced any evidence. This is practically, your lordship, a case based on the evidence of the plaintiff itself, your lordship. The judgment and decree has been passed.
The defendant has not adduced any evidence.
No evidence. He has not adduced any evidence at all. On the other hand, your lordship, there were 3 witnesses, your lordship, in favor of the plaintiff. They have supported, your lordship, the case of the plaintiff, that he is the owner of the land, he is the tenant, this dependent, and he has not paid the rent.
No, you see one thing. The trial court has passed the decree under the Urban Area Rent Control Act. So the appellate court has dealt with the same and affirmed the same. Is it not under the Urban Area Rent Control Act?
Your lordship, not at all, your lordship will come to the order person, your lordship.
No, I am asking you for the reason that Mr. Sayola has suggested that it can be remanded to the trial court for dealing with the same in accordance with law.
No, your lordship.
So you are not conceding to such submission.
Lordship, in the result, the decree passed, decree, your lordship. Decree is not based on the Urbanized Land Control Act, your lordship. Decree is on the basis of defaulter. And non-payment of rent, your lordship, and bona fide requirement. Decree has been based on these 2 ingredients, your lordship, and on that basis, your lordship, trial court passed. And the trial court's judgment to that effect, the appellate court has actually agreed, your lordship, ratified the findings, not on the basis of the Urbanized Land Control, your lordship. Generally, your lordship, that these findings, that is defaulter as well as the bona fide requirement, your lordship, it is in favor of the plaintiff respondent, your lordship. Both the court has found, your lordship. Now, your lordship will find in the result that decree passed by the learned court in such and such is upheld and the title appeal is disposed of on contest which cost prepared decree accordingly, your lordship. This is the just I am taking the issue number 3 and 4, your lordship, at page 49. Why it is not a case for remand, your lordship? I will come to that.
Okay, then let Mr. Sayola argue first. If he were not conceding to his submission.
I will convince your lordship.
No, that's all right. Since he is the appellant, let him first complete his argument.
I think he has completed your lordship.
Will you complete that? Complete. My lord, if your lordship will see that, that is why the substantive question law has been framed. Because the trial court judgment is upheld. Now, trial court judgment upheld means, my lord, that is the trial under the basis of rent control act. As my lord, had it been under the Transfer of Property Act, I would have an opportunity, my lord, that is my right, my lord. That Supreme Court has also said I shall place a judgment to the Supreme Court, my lord. Because 114, I have a right, my lord. I can-
114.
114 of the TB Act. I can offer the rent.
That's good.
That I'm okay.
You pledge the judgment?
My lord? Yes. Well, just, my lord, your lordship, 2002, 5 SCC 1440. Two paragraphs only, my lord, paragraph 20, 21. 5 2 SCC 440. 440. Paragraph 20, 21. At page 456. My lord, in that case, my lord, there was Accommodation Control Act, 1 MP. There is a provision in that act also.
Which paragraph you are
Paragraph
reading?
20.
Pardon?
20. 20.
20. Yes.
Even if section 13(2)(1) and the proviso would not have been enacted, there was section 114 of transfer property took care of such situations. The provision in the rent control legislation, which obliges the tenant to pay or tender the area rent during the course of the hearing and relieve the tenant from the consequences default in payment of rent, is equitable principle of granting relief against forfeiture within the exercise of discretion vesting in the court. The Transfer of Property Act did not in terms apply to the state of Punjab. However, the principle underlying or contained in such a provision of the Transfer of Property Act as are essential the principle of equity, justice and good conscience have been held applicable to the state of Punjab and Haryana. Section 114 TP Act embodies one of the such principles. The rule of equity enshrined in Section 114 of Transfer of Property Act, where a lease of movable property is determined for purposes of non-payment of rent and the lessor files a suit for ejectment of lessee, court exercises discretionary jurisdiction in passing an order relieving the lessee against the consequence of forfeiture if at the time of hearing of the suit, the lessee pays or tender to the lessor the rent in arrears with interest and cost for such security, so in substantial. Having appointed at the time for payment of the court still remains the judicial extended time. Even the time appointed concerned decree can be conferred under Section 114 of TP Act of wide amplitude and guided by the principle of justice, equity, and good conscience. And the court would ensure the conduct of the parties, comparative hardship, and in favor of such. Now, paragraph 21. The question whether which stares us is whether in enacting the section 13(2)(1) and proviso thereto, we assume that the legislature intended to place the tenants in a situation worse than what it would have been under the principle of the deducible under section 114 of TP Act. Even if this provision would not have been there, we cannot attribute this misplaced wisdom of the legislature without being uncharitable to it. We are definitely of the opinion that by enacting section 13(2)(1) and the proviso body of the act, legislature has intended to confer the tenants a protection larger and more beneficial than it would have been if the provision was not made. Now, this is that. My question is this, my lord, this is my right, my lord. This is a right has been given to a tenant under section 13(14), my lord, because in Assam, my TP Act is applicable. And since this property lies outside the town area, So rent control is not applicable. And the appellate court, my lord, if you also see, my lord, has not uttered a whisper that the finding of the learned trial court that rent control is applied was wrong, my lord. Because he had upheld the judgment of the trial court. He said that he is defaulter. Defaulter, my lord, has said, hey, I have nothing to say about this. But he has upheld the judgment. And that is why, my lord, the question of law has been framed without a whisper, my lord, that rent control act is not applicable. If appellate court also, my lord, consider that rent control is not applicable, I can offer the rent to appellate court also. My lord, that is also my right. Even if, my lord, the matter is remanded back to the appellate court also, I can do that, my lord. Because appellate court has some jurisdiction, my lord. PPX will apply.
Okay. So your contention is that it can be remanded either to the trial court or to the appellate court.
That is what I. This is my own sense. Because my right has been cut in.
Okay. Yes, I'll.
Lordship, I would like to answer the first question. That is 114. 114, it is not applicable here because he has not taken the plea. That is, the defendant has not taken the plea of 114 in the written statement. For the first time in the second appeal, he has taken the plea. That too, it is a new point, Your Lordship. As per the Supreme Court judgment, other Your Lordship. For the first time in the second appeal, no new plea can be taken unless there is foundation and necessary pleadings in the written statement. Now, here in this case, otherwise also it is not applicable. Why, Your Lordship, I am coming. This section 149 placing. So, to get the benefit of 114, Your Lordship, petition must be filed before the trial court before the judgment is given. Before the judgment and decree passed. Before this is the provision, Your Lordship. And in this regard, Your Lordship, our High Court decision and other decisions related. I am just placing the provisions, Your Lordship. 140, that's for property. 140, relief against forfeiture for non-payment of rent. So here must be forfeiture. There is no forfeiture. Just mere non-payment of rent. Your Lordship, I am taking your honor through the provisions where got it. Where a lease of immovable property has determined by forfeiture for non-payment of rent and the lessor sues to eject the lessee. If at the hearing of the suit, the lessee pays or tenders to the lessor the rent in area together with interest thereon and his full cost of the suit, or gives such security as the court thinks sufficient for making such payment within 15 days. The court may, in lieu of making a decree or an ejectment, decree for ejectment, pass an order relieving the lessee against the forfeiture, and thereupon the lessee shall hold the property leased if the forfeiture had not occurred. Here, Your Lordship, it is in respect of land, not in respect of house. And that is just for a property which is beyond the territory of the urbanized land control. So, in place of judgment and decree, Your Lordship, there will be an order, and it must be, petition must be filed before the court, trial court, Your Lordship, that I am ready to pay the area rent with interest as well as the cost of the suit. These are the three ingredients, Your Lordship, you still have to comply. Not in the appellate step, not in the second appellate step, part of the trial court stage, Your Lordship. His petition, Your Lordship, this ground, Your Lordship, not taken in the written statement, not in the first appellate court. In the second appellate court, Your Lordship, for the first time is taken. So that permission cannot be availed of by the appellant, Your Lordship, in this manner, Your Lordship. Because it is before the judgment and decree is passed. There will be no degree of, will be degree of ejectment, but there will be order that will be continued only subject to payment of the grant, prevailing grant, area grant, but as well as the cost of the suit. This is not the case here. Last, there was the forfeiture. Forfeiture has been defined under section 111G. 111G, your lordship, there is no forfeiture. There was the forfeiture. 111G, determination of lease. Determination of a lease of immovable property determines A, B, C, D, G, your lordship. A lease of immovable property determines by forfeiture, that is to say, in case the lessee breaks an express condition, lessee breaks an express condition which provides that on which thereof the lessor may re-enter into it. Lessor may re-enter into it on breach of the terms and conditions, your lordship. There is no such agreement empowering the landlord, your lordship, that on breach I will enter into it. Because there is no payment of rent. So these conditions is not your lordship, no written agreement here, no on that day. It is verbal agreement. That's why, your lordship, there is no forfeiture so far. One is concerned. In case the lessee breaks an express condition which provides that on breach thereof, the lessor may re-enter. Re-enter. Two, in case the lessee renounces his character as such by setting up a title in a third person or by claiming himself, your lordship, any title thereon. So he must claim title or himself, that is the second engagement. Thirdly, your lordship, the lessee is adjudicated and insolvent and the lessee provides that the lessor may re-enter into it. So 2 and 3 is not applicable. So for 1 is concerned, your lordship, there is no such lease agreement, your lordship, empowering the landlord, your lordship. So under the definition of forfeiture, your lordship, under the definition of forfeiture, your lordship, under section 111G, your lordship, there is no forfeiture. So forfeiture is the criteria here, your lordship, under section 140. 140, your lordship, in this regard, your lordship, to get benefit, your lordship, I am placing petition, your lordship, which I have already filed, your lordship, for the honorable court. It is already here in it. Your lordship, AIR 1964, Gauhati 102, your lordship. That is there. Paragraph 10.
Nice.
Huh?
It is with
Okay.
good. Nice.
Okay.
Assist.
To get that benefit, your lordship, this High Court is very clear, your lordship. The Supreme Court decision, your lordship, that is not applicable here in this case. So para 7, your lordship will find.
Yes.
Para 7, the next point was that under section 114 of the Transfer of Property Act, as the defendant appealing was willing to deposit the entire areas of rent together with interest and full cost of the suit, he should be relieved of forfeiture of the, so he will be relieved of forfeiture of the tenancy for non-payment of the rent. His contention is that even though the plaintiff is entitled to get a decree of ejectment for ejectment under section 6 of the act, still the act does not in any way abrogate the provisions of Transfer of Property Act, and the defendant is entitled to get the benefit under section 114 of the Transfer of Property Act. There are 2 points against the appellant in giving him relief under section 114 of the Transfer of Property Act. Section 114 is only affected where a lease of immovable property is determined by forfeiture for non-payment of rent. So, your lordship, to be forfeiture, we'll have to go back again to section 111G. Section 111 of the Transfer of Property Act. When a lease of immovable property is determined under section G, subsection G of section of the section lays down that the lease of immovable property is determined by forfeiture, that is to say, in case the lessee breaks an express condition which provides that on breach thereof the lessor may re-enter, or in case the lessee renounces the character as such by setting up title in the third person or claiming title in himself, or the lessee is adjudicated and insolvent, and the lessee provides that the lessor may re-enter on the happening of such event, and in any of these cases, the lessor or his trustworthy give notice in writing to the lessee of his intention to determine the lease. It is urged that there is an express condition of the lease to pay the monthly rent, and the plaintiff has brought the suit for rejectment on the ground that the conditions of payment of rent has not been carried out. Thus, section 140 TP Act is attracted. Two things are necessary before subclause G of section 111 can be attracted, that there should be an express condition in the lease for payment of rent, that there should be a clause for re-entry. There should be a clause for re-entry in the lease in the case of default of payment of rent. In the present case, there is no such provision. In the present case, there is no such provision in the lease, and thus there could not be any provision of the lease for non-payment of the rent. If there was any forfeiture of the lease for non-payment of the rent, section 114 will not be attracted. So here in this case, your lordship, first thing that 114 benefit they have not claimed in the written statement, nor they have filed any petition before the trial court that your lordship or your honor, that I am ready to pay the compensation, that is the rent, plus interest plus cost of the suit. Kindly, this suit may be disposed of on my concession that I will pay everything. Is it their case, your lordship? This is not their case, your lordship, but the first time here in this case, they have taken this plea, your lordship, neither in the first appellate plot, in the written statement, nor in the trial during the hearing, your lordship. Reference in this connection may be made to the case so and so, not so and so, so and so, so and so. The next, your lordship will go, your lordship, that is paragraph 910. It will throw light upon this case, your lordship. So this case is not actually attracted. This case does not attract the provisions of 140 in view of the necessary lack of necessary ingredients. Now, next question is, your lordship. Here, next answer will be, your lordship. Here, 1956 Gauhati 130 on section 114, your lordship. दिया আছে আমার গোটি প্লাস दिया আছে খালি
What is the citation?
Lordship, AIR 1956 Gauhati 130 আছে না আমার কাছে নেই।
So why you have submitted all this citation earlier?
AIR 1956 Gauhati 113.
Okay.
In fact, the matter is heard by Justice Soikia, reserved the judgment, but thereafter, that is released.
Okay.
Your lordship will come to paragraph 4. It is
Yes,
then
got
paragraph.
Got it.
It is then contended that the Assam Urbanist and Total Act has no application to this case, and the defendants were not liable to be evicted. The protection of the Assam Organized Control Act was claimed by the defendants that themselves of the that they were not deporters in the meaning of the act, and therefore they could not be the act gave no protection to the defendant, and the claim of the plaintiff should be valid. Mr. Mehdi Soita argued that under section 140 TP Act, he should be given relief against forfeiture for non-payment of rent. Unfortunately, Mr. Mehdi did not claim the benefit of this section either in the courts below, or it seems even if such a relief could be given to him, it is now too late to do so, because I understand that the defendants have already delivered possession of the premises to the plaintiff after vacating the same. The court has discretion under section 114 TP Act to grant the relief against forfeiture or to refuse this. In this case, it does not appear to me that the conduct of the defendants in withholding payment of rent to the plaintiff, as they have done for about a year and a half, without any adequate cause justified any such relief. It is also argued by Mr. Mehdi that the notice to quit is illegal. It is not illegal. So for court is concerned, you have already sufficient. So this relief cannot be given because it was never raised before the trial court, nor it is in the plaintiff. Same case, your lordship. So that 140 your lordship, but the third time it cannot be considered by the sovereign court in view of the fact that it is actually ought to have been raised that point in the trial court, and the trial court definitely would have given the. Now this is a matter of the year, your lordship. I think it is a case of 2010, your lordship. 2010 it is 15 years. Next month should be your lordship. Now, your lordship, next I come to the decision 1974 to Supreme Court cases 453 on the point of merger, your lordship. So before the second appellate court, your lordship, the order challenge or the judgment challenge is the court of the first appellate court, your lordship, or the first appellate court, not the trial court, your lordship. How it merges and what is the implication? Your lordship, this is 1974 two Supreme Court cases 453, paragraph 16 below. In cases where the decree of the trial court is carried on in appeal, lordship got it. In cases where the decree of the trial court is carried in appeal and the appellate court disposes of the appeal after contested hearing, the decree is to be executed is the decree of the appellate court and not of the trial court. In so and so, the Privy Council, while holding that the limitation for years within which an application for final decree must be made runs from the date of the decree of the appellate court quoted with approval, the statement of law contained in the judgment of a learned judge of the Allahabad High Court to the effect when an appeal has been prepared, it is the decree of the appellate court which is the final decree in the case. The Privy Council also adopted the statement contained in the judgment of the J to this effect. When a munchi passed the decree, it was offered to the plaintiff or the defendant to accept the decree or to appeal. To accept that decree or to appeal. If an appeal is prepared, the final decree is the decree of the appellate court of final jurisdiction. When that decree is passed, it is that decree and only that which can be made final in the cause between the parties. Thus, when the decree of the court of first instance is confirmed by the High Court and later the decree is confirmed by the Privy Council, the decree capable of execution is the decree of the Privy Council. In that case, the decree passed by the district judge in 1987 awarded future mean provision to the plaintiff. The decree was reversed by the High Court but was confirmed by the Privy Council. So when the matter came back to the executive process, the Privy Council held that the decree which the court had to execute was one passed by it in 1895. That is, since that the decree, the district judge's decree was confirmed, and the decree 1895 clearly carried on its main purpose up to its date. An application of this very principle is that is the murder of principles in lordship. Doctrine of murder in lordship 17. An application of this very principle is the result that if the court of appeal confirms various reverses the decree of the lower court, the decree of the appellate court is the only decree that can be amended, or that the limitation for executing a decree runs from the date of the decree capable of execution, that is the decree of the appellate court, which supersedes that of the decree of the first instance, or that if the mean profits are ordered from the date of the suit, the expiry of the 3 years after the date of the decree to be considered is that of the decree capable of execution, so that if the decree of the trial court is confirmed in appeal, their 3 years will begin to run from the date of the appellant. That 18. The decree, therefore, which Section 17D affords the court to set aside is the decree which is capable of execution, which in this case is the decree of the decree passed by the High Court on January 8, 1969. 19. The fundamental result of the rule that there has been an appeal. The decree to be executed is the decree of the appellate court, is that in such cases the decree of the trial court is merged. The decree of the trial court is merged in the decree of the appellate court. In course of time, this concept, which was originally restricted to appellate decrees on the ground that an appeal is continuation of the suit, came to be gradually extended to other proceedings like revision and event to proceedings before it extended to the other proceedings like the revision and event to proceedings before the constitutional and executive authorities. So, 20, Your Lordship. Now it will be appropriate to refer to the decisions bearing on the principles of murder. Now, 21. In such and such, the question which arose for the decision was whether the order passed by the income tax officer allowing the registration of a firm merged in the order passed by the appellate assistant commissioner in the appeals filed by the firm against the order of the assessment. If it did, the commissioner of income tax could not, in the exercise of his divisional powers under section so set aside the order of registration passed by the income tax. This court, on the merits of the matter, that though the appellate order of the appellate assistant commissioner was the only order which was valid and enforceable in law, what marked in the appellate order was the income tax officer's order under appeal and not his order of registration, which was not and could not have become the subject matter of an appeal before the appellate authority. The position in regard to this determines the position in regard to the doctrine of murder was stated thus by Gajendra Katkar so. There can be no doubt that if an appeal is provided against an order passed by a tribunal, the decision of the appellate authority is the operative decision in law. If the appellate authority modifies, reverses the decision of the tribunal, it is obvious that it is the appellate decision that is effective and can be enforced. in the law, the position would be just the same even if the appellate decision merely confirms the decision of the tribunal as a result of the confirmation and affirmation of the decision of the tribunal by the appellate authority. The original decision merges in the appellate decision and it is the appellate decision alone which subsists and is operative and capable of enforcement. Now your lordship will find the judgment and the decree which passed by the Munship, your lordship, as soon as the appellate court delivered the judgment, your lordship is merged. As soon as it merged, your lordship, it is not that this judgment will prevail. The execution will be, your lordship, on the basis of the first appellate court judgment. If it is, your lordship, before the Honorable High Court, your lordship, then it is the Honorable High Court itself. If it is Supreme Court, lordship, Supreme Court judgment will be put to execution, your lordship. This is the doctrine of merger. As per that, your lordship, the first appellate court here, that is the civil judge, your lordship, nowhere it has inspired that this is the matter decided under the provisions of the Urban Areas and Corporate Act. Nowhere also. No whisper, nothing of that, just no mention of any decision under the Urban Areas and Corporate Act. So now, as soon as the judgment and decree has been passed by the first appellate court, your lordship, the judgment and decree passed by the civil Municipal Court, your lordship, that is known as that, have ceased to have the force, your lordship, and the enforceable decree will be, your lordship, that of the first appellate court. Now, your lordship is hearing the matter, your lordship. Now, if it is hard, your lordship, this way, that of whatever decision takes, your lordship, that this decision.
No,
this
okay.
decision, your
There is no doubt about this proposition.
So
All right.
from that angle, your lordship, my learned friend can't say that he has been prejudiced in any way. So for the defaulter is concerned, so for benefit under section 114 is concerned, your lordship, that goes there, that is known as your lordship. He can't take the benefit out of that provision because it is not his case, your lordship. The matter was raised before the trial court, first appellate court, then it is raised, your lordship. Your lordship, in this regard, one decision I am placing, your lordship, of Supreme Court, your lordship, that is Santos Hazare versus Swencho, 2001, 3 SCC 179. It will be asked.
Yes.
Para 14, your lordship will come. Because your lordship will decide here the substantial question of law. What is the substantial question of law here? Not on facts, your lordship. There are 14 years old find a point of law which admits no two opinions. Maybe a
Paragraph
proposition
number?
of law.
Paragraph number?
Paragraph number 14, your lordship.
Yes.
A point of law which admits of no two opinions may be a proposition of law, but cannot be a substantial question of law. To be a substantial question of law, a question of law must be debatable, not previously settled by law of the land or binding precedent, and must have material bearing on the decision of the case. If answered either way, so far as the rights of the parties before it are concerned. To be a question of law involving in the case, there must be first foundation for it. To be a question of law involving in the case, there must be first foundation for it laid down in the pleadings. And questions should emerge from the sustainable findings of the fact arrived at by the court of facts, and it must be necessary to decide the question of law for a just and proper decision. It's indicated an entirely new point raised for the first time before the High Court. is not a question involved in the case unless it goes to the root of the matter. Unless it goes to the root of the matter. Your Lordship, there are 114 goals. Now defaulter comes in, your Lordship, defaulter, it is the concurrent finding by both the court. Is where that your Lordship concurrent finding, defaulter is the finding of fact. There are a number of decisions of the Supreme Court. Bona fide requirement is the finding of fact. Defaulter is a finding of fact that cannot be interfered with, your Lordship, in second appeal. Even if it is erroneous on fact, your Lordship, the Supreme Court has held that that cannot be interfered with because that is on fact. It will therefore be dependent on the facts and circumstances of the case. Now, your Lordship, 15, I'm just referring some findings of the Supreme Court, your Lordship, in the midst of 15, your Lordship. The appellate court has jurisdiction to refer, affirm the findings of the trial court. First appeal is a valuable right of the parties, and unless restricted by law, the whole case is therein open for re-hearing both as a question of fact and law. Here, your Lordship will find under order 42, 41, your Lordship, 32, rule 32. Order 4, 41, rule 32, your Lordship, under that provision, the first appellate court has rendered its judgment. Under order 41, rule 33, your Lordship will find
Rule?
under 41, rule 33, your Lordship. Got it, yes. Rule 33.
Yes.
The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or order, decree or order as the case may require, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decree in a cross suit or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decree, provided that the appellate court shall not make any order under this section. So under this rule, your Lordship, 33, the appellate court has full discretion to de novo decide the matter, your Lordship, consider everything, this facts, law, your Lordship, documents, everything, your Lordship. And if after that court finds that whatever finding has been given by the finding, your Lordship, what procedure adopted, your Lordship, that is admitted here. Finding is that you are defaulter, non-payment of that. Supposing it is decided under the transfer of property that you are defaulter. Supposing it is under the rent control, like you are defaulter. So you are liable to be affected under both the act. There is no jurisdictional error, your Lordship. That being the position, so under this rule, order 41, rule 33, the first appellate court has rendered the judgment. It has given, your Lordship, independent surface, but so for finding decree is concerned. What is the decree, your Lord? Decree is the substance of the judgment. Whatever has been the judgment, your statement in the judgment, your Lordship, those statements, it is re-recorded, your Lordship, in the shape of order. Order, your Lordship, from that order, decree is prepared. So what is the order, your Lordship? That he is a defaulter. Once he is a defaulter, your Lordship, he is bound to pay, it is obligation, your Lordship, on his part to pay the rent past existing plus future rent, your Lordship, till he is evicted. So these are the things, your lordship, and on that, your lordship, it is his independent positive finding, which is actually the finding of the trial court also. Just because confirmed or ratified or say trial court decrees all that, your lordship, that does not mean that this appellate court, your lordship, have followed the procedure under the Advantage and Control Act. Procedure is practically same. Court has jurisdiction under both the acts. So no prejudice has been caused to them, your lordship. And for that, your lordship, first we'll have to minus the provisions of section 114. They are not entitled to get that benefit, having not obtained that relief, your lordship, in the trial court itself. Now your lordship will come to the other decision of on murder, your lordship. 2010.
No, already you have referred some of the decision. So why?
This is Santos Hazari, your lordship, on the new point cannot be raised.
Yes. So merger, you have already referred one decision. Is it necessary to multiply the same?
On the point of murder, your lordship, that what is murder, your lordship? Principle has to learn very well. Murder means the murder of the subordinate court with the higher court.
No, there is no doubt about it.
Lordship. So if that be the position, so why they are harping on the municipal court judgment? Municipal court judgment is known as your lordship, and that cannot be your lordship argued here, because they are very title, cause title, your lordship, so they have actually challenge the appellate court judgment. Now your lordship will go through this judgment, your lordship. Just one para I am referring, your lordship, just para 30.
Which judgment?
It is 2010-11 SCC 153.
Yes. Now this is again on the doctrine of merger.
Lordship, just one paragraph, your lordship. 13. The doctrine of merger has its origin in common law. It has its application not only in the realm of judicial orders, but also in the realm of states. In its application to orders passed by the judicial and the quasi-judicial courts and authorities, it implies that the order passed by lower authority would lose its finality, and efficacy in favor of an order passed by a higher authority before whom correctness of such an order may have been assailed in appeal, revision. The doctrine applies regardless of whether higher court or the authority affirms, modifies the order passed by the lower court or authority. So this paragraph will clear the matter, your lordship, whatever they are arguing, your lordship. So time has value, your lordship. Now, just your lordship, it is the case of the year 2010, it is more than 15 years, your lordship. Again, remand, your lordship, which can be decided. And otherwise also it is not fit case for remand, because it is covered by the decision of the Supreme Court, our High Court. There is another decision, your lordship will go through on the same point. Next 2004 8 SCC 724. Next, I'm coming, your lordship, another decision on merger, your lordship. That is 2013 4 PLT 177 of our High Court. That is paragraph 23-22, your lordship.
2000? What is the citation?
Lordship. Our High Court decision is 2013 4 PLT 177.
Yes.
22. You have will find. The learned counsel, I am coming directly after 23.
Mm.
In this, that connection, the learned counsel for the respondent hearing has referred me to the decision rendered by the Honorable Supreme Court, in cases where the decree of the trial court is carried on inaccurate, and the appellate court disposes of the appeal after contested hearing, the decree to be executed is the decree of the appellate court, not of the trial court. In such and such case, the privy council, while holding the limitation, now rest your lordship, the previous decision which I have referred, that if an appeal is prepared, the final decree is the decree of the appellate court of final jurisdiction. Now your lordship, supposing this lordship appeals the judgment of the first appellate court. So decree to be executed will be your lordship judgment, your lordship. Not of the first appellate court, nor of the trial court, your lordship. 140 is concerned, your lordship, already I have placed two decisions, your lordship. I'm placing section 99, your lordship. Supposing your lordship, the trial court committed irregularity, your lordship. Not illegality, your lordship. Little bit irregularity. What will be the effect? Your lordship, section 99.
Section 99 of
9 of the CPC.
yes.
No decree to be reversed or modified for error or irregularity not affecting the merit or jurisdiction. Merit or jurisdiction, your lordship. So far merit is concerned, defaulter, not paid grant. So that is why defaulter, that is the merit, your lordship, both the courts. Now they can't say, your lordship, by remanding the matter, your lordship, they will be safe from being defaulter. It is not their case, your lordship. Their case is, your lordship, that they will avail the benefit of section 140. That benefit cannot be taken availed of, your lordship, in view of the fact that the trial court, while deciding the matter, they did not file any application to pay the rent plus interest plus the cost of the suit. That is still gone. Here in the second appeal for the first time, as I have shown, that is
No, you are repeating the same thing.
lordship.
You are repeating the same thing.
Lordship. Sorry, your lordship. A decree shall be reversed or substantially varied, nor shall be, no decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of any rejoinder or non-joinder of parties or cause of action or any error, defect or irregularity in any proceedings in the suit not affecting the merit of the case or the jurisdiction of the court. So these provisions under section 90 of 89 of the CPC, lordship, it comes into play in our case also, your lordship. Mere irregularity, he has mentioned the trial court, your lordship. For that, your lordship, enter judgment of the trial court, and his judgment will be, your lordship, nullified, your lordship. That is not the law. It is a mere irregularity. On that point, our own issues that here, your lordship, of the High Court, your lordship. First decision I am citing, your lordship, this 2018-12 SCC 500. Yes, sir. Paragraph 4, your lordship. Paragraph 4. The learned senior counsel inviting our attention to section 99 of the Code of Civil Procedure, Contents that no decree shall be reversed or varied. Substantially on account of non-gender, misgender of parties. Section 99 of the Code Civil Procedure runs as follows. No decree shall be reversed, substantially varied, or shall in case be remanded in appeal on account of any misgender, non-gender of parties, cause of action, or any error, defect, or irregularity in any proceeding in the court, not affecting the merit of the case or the jurisdiction of the court. Five. The provisions in our view is crystal clear. No decree can be reversed or substantially varied in the appeal on account of misgender, non-gender of parties. Under section 141 of the code, in regard to the suit shall be followed as far as it can be made applicable to proceedings in any court of civil jurisdiction. Therefore, what is provided under section 99 of the code civil in respect of appeal would apply to division as well. So here also it is applicable, your lordship, but it is applicable to division, your lordship. So here the what point was your lordship misgender. So for the apart from misgender, there are three other images also your lordship involved. That is any error apparent, your lordship, defect or irregularity. Error, defect or irregularity. Whatever may be the case, your lordship. If committed any error, defect or irregularity, that is your lordship, it can be avoided, ignored, your lordship, in view of the appellate court judgment. Appellate court has not referred any ordinance and court to that. That's why, your lordship, they are not entitled to get judgment. Our high court decision is there, your lordship.
No, not necessary in view of the decision of the Supreme Court.
I'm just referring, your lordship, decision 2007 to GLT 859. Yes, sir. Your lordship will go through their judgment also, your lordship, and it's a big case, your lordship. There is no question of remand, your lordship. It should not be remanded, your lordship. Considering the time already left, your lordship, 15 years, if it is remanded, the same thing will happen, your lordship, will be deported. It is not that, your lordship, will be declared not deported, your lordship. It is not that, because that is not the point. Point is, your lordship, they are referring, your lordship, 140, which is not applicable. From that angle also, your lordship, the matter is clean, your lordship. The matter is clear. That's why, your lordship, this suit is liable, this appeal is liable to be dismissed, your lordship. No merit.
Okay. Mr. Sahewala, any reply?
Yes, madam. A very short, madam.
Hmm.
Madam, here, madam, in the matter, a pleader's notice was issued. If your lordship will see the page 8 of the plain, madam, in the memo of appeal.
Plaintiff at page number?
If you start, madam, earlier, but I am referring to page 8, madam. It starts at page 5. But I am referring to 8, madam. Only
Yes.
few sentence, madam, I wanted to say. Regarding the notice. Serial page 8, well, internal page
In
is
the
4.
appeal.
Madam,
In the appeal.
in the appeal. Serial page 8, internal page 4, madam. That's right.
Yes.
Madam, the last about 10 sentences, madam, your loss will see. This time, although there was a legal notice of demand was sent to the defendants, to the plaintiff's advocate LP Dr. Sibsagar by registered post on so and so to quit and vacate the criminal premises and to make clear all the dues, asking the defendants to clear the area of rents and to quit and vacate, fixing ultimate date up to so and so for vacation and payment on being satisfied with the defendants, unreasonable conducts which are not continued to maintain the relationship between landlord and tenant, as the term of tenancy has already expired by the said 30th day of April 2010. Hello, so this notice was there, my lord, to quit, my lord, that was for the purpose of deporter. So what my learned friend is saying, my lord, that is, that 140 is not applicable, to court also says, my lord, copies are by non-payment of rent. That's the condition, my lord, that a specific condition is there, my lord, the lease deed, that payment is being made, my lord, so and so. And now, well, आपको कोलास नहीं की हाँ आपको कोलास नहीं अपना हो गो यार सेकंड क्वेश्चन हाँ क्यों ऐसे जे now my lord in the appeal memo my lord before the civil judge my lord we have taken 3 grounds especially my lord that rent control act will not be applicable ground number 11 13 and 27 that is not here my lord in the accord is there appeal memo I can submit my lord the copy of the memo of appeal my lord with me ground number I'm just it I think my lord number 7 13 27 my lord you'll also see my lord especially we said that this is a land this is a property situated outside the urban rent control act so it is not applicable so it was the bounden duty of the appellate court my lord to give a finding on that my lord that is why the substantive law has been framed my lord.
Okay.
My lord, and moreover, my lord, my learned friend has submitted my lord, that on the merger. I say merger is there, my lord, but the appellate court decree, my lord, whether it can be executed. My lord, if you also see at page 52 of the memo of appeal, my lord, the decree prepared by the appellate court. Ultimately, they have to go to that trial court decree, my lord, to execute it. Practically, my lord, my lord, when appellate court dismissed appeal. At page 53, my lord, you'll also see
103 of
53, my lord,
53 of
the memo, my lord, appeal.
memo of appeal.
The decree starts at page 52. I'm just saying.
Yes.
My lord, it is ordered that the judgment and decree passed by the London trial court in title suit number is upheld and title appeal is dismissed and disposed of. My lord, in fact, my lord, ultimately execution is to be made on the basis of the trial court. With this technical objective. And moreover, my lord, when we have taken the special ground, my lord, the grounds has been taken by the appellate, my lord, before the appellate court. The appellate court was duty bound, my lord, to give a finding on that basis. That is why, my lord, substance question law has been that without giving in, my lord, saying in, he has upheld the judgment. Upheld means that judgment passed under control. That has been upheld. Defaulter is another aspect of it. My learned friend is marking too much on the point of defaulter. I'm not saying that I'm not defaulter, but my right is there under because my lease has expired. They say they issued a notice saying that the lease expired and you pay as a vacant. This is my humble submission, my lord, that it's a fifth case, my lord, for demand either to the trial court or the appellate court, my lord. The appellate court should be finding it, my lord, and where we can get a chance to you're right, man. That's very fast.
Heard, Mr. G. N. Chahela, learned senior counsel assisted by Miss learned counsel for the appellant, and Mr. S. Ali, learned counsel for the respondent. Argument concluded, judgment reserved.
The numbers 25 to 27.
Yes.
My lord. Three appeals, that is appeal number 91, RSA 9123, RSA 10123, and RSA 110. The opinions are same. But of course, the respondents are different. So it would be hard simultaneously.
Okay. I'll keep it in the Whether all these three appeals against the same judgment of the appellate court, first appellate court?
Three judgments.
Three different judgment.
Different judgment.
Different judgment.
But the same substantial question of laws are framed in all the three appeals.
So all these three appeals may be hard together, but the judgment will be different because the respondents are different. Of course, appellant is the same. And the land involves, of course, area is different, but bag number, portal number, and other things are same. So these three appeals may kindly be hard together.
Okay.
Fixing another day.
Okay.
After 5 weeks, because during the Bihu time, I may go outside in connection with some treatment.
So today you are not ready to argue the matter?
No, sir, it will not be concluded. I may start, but it will not be concluded. It will take time.
Okay. Then after vacation, Mr. Chauhan?
It depends on the opinion side, I have no idea.
Okay.
Because it will not be completed on today.
Okay.
So after 5 weeks, it may be.
Okay. As agreed by learned advocates of both the parties, SSL list these three appeals, being RSN number 91 of 2023, 101 of 2023, and 110 of 2023, together after BU vacation. Should we fix a date?
After 5 weeks.
After
5 weeks.
5 weeks.
I will go outside in connection with my treatment. So it will not be possible to be available during the month of April. So after 5 months.
Okay, in the
5 weeks.
first week of May?
Yes, after 5 weeks.
Second week of May.
No, 5 weeks. 5 weeks. 5 weeks. That is not like it. 5 weeks going to do. After 5 weeks.
The 28th May.
No, date to fix করবো না লাগে
No, no, oh, okay. After 5 weeks.
Item 28.
Yes, may I please, your Lordship, the appellant is the defendant, your Lordship, in the original suit, and the respondent one is the plaintiff. He filed a suit, your Lordship, for first possession and eviction of the defendant, your Lordship. There is the appellant here in this appeal, your Lordship. Plaint is at page number 6, annexure 1, your Lordship. Annexure 1, page number 6, your Lordship. Page 7, para 2, your Lordship. That thereafter on 6/2022, 2002, pro forma defendant number 3 sold the below schedule suit land and house to the plaintiff through a registered sale deed and delivered over possession thereof to him. Him means Lordship plaintiff. Being the owner and possessor of the said property by way of purchase, the plaintiff renovated the house and made it fit for living. That subsequently to buying the suit land and house, the plaintiff started residing thereon with his old mother and family while serving in a higher post in Badarpur Power Grid. In the month of November 2014, the plaintiff was transferred from Badarpur to Rangia as there was no provision for keeping his old mother and the family at his new place of posting. He kept his wife and son temporarily in his house situated at Panchayat Road, Silchar, for the sake of the education of his son and so and so. Next, that the plaintiff, with the intention of his own mother, allowed the defendant number 1, defendant number is the appellant here, your Lordship, to visit the house of the plaintiff at Hailagandi from the house of defendant number 1 in the village Sribani for looking after the old mother of the plaintiff, but the cunning and shrewd defendant number 1, along with his family, under the instigation of the wicked person of the locality, started staying in the house of the plaintiff without his permission and knowledge and set up a business thereon by opening a stationery shop. Defying the strong objection of the old mother of the plaintiff, defendant number 1 illegally gave a room of the house to defendant number 2 on rental basis, and thus he has been earning a huge amount. Now, your Lordship, next page, page number 8, para 8, your Lordship. The cause of action of the suit arose within the jurisdiction of this court on 6/2002, date of buying the suit and house of the plaintiff, and on 4/9/2013, date of cancellation of the trade license in the name of defendant number 1, by pro forma defendant number 6, in the month of 2014, date of the month of transfer of the plaintiff from Badarpur to Rangia, and so, your Lordship. So basically, your Lordship, the suit was for khas possession, your Lordship, and defendant allowed the plaintiff allowed the appellant here in your Lordship to stay in his house without any permission, your Lordship, but he was not letting go, your lordship, and because of that, your lordship, he filed a advocate notice to vacate the suit premises, your lordship, but he was reluctant to vacate and ultimately, your lordship, the suit was filed, praying for khas possession and eviction of the appellant here in your lordship. Now, your lordship,
So
written
the suit
statement
was decreed
decreed, your lordship, in favor of
on the
plaintiff.
ground of adverse position.
Yes, lordship, I am mainly on the adverse position. Only thing is to consider, your lordship, whether the suit was preferred within the period of 12 years, a limitation period or not. If yes, lordship, I am no case, and if not, your lordship, then
Limitation period.
yes, lordship.
What is the period of limitation?
12 years, your lordship.
12
Within the
years.
12 years
12 years from who is that?
from the date of your lordship. My contention, your lordship, may find at page number 18. Page number 18, your lordship, para 12. While denying the averments made in the plaint, your lordship, I have the true account of the matter is as follows: that original house of the plaintiff, defendant number 1, their other brother and mother is at village Srivani under Ramkishnagar police station and Remit Sagul in the district of Koringanj. The father of the plaintiff, defendant number 1, and their other brother had his house and some agricultural land situated in a very backward place. During his lifetime, Dhirendra Kumar Dev, the father of the plaintiff, defendant number 1, and their other brother sold some of his land and gave the money to the plaintiff to purchase land in the joint name of the plaintiff, defendant number 1, in their other brother in Hailakandi town, but subsequent to the death of their father, the plaintiff, with an ill and ugly intention, brought the suit land and his house in his own name from defendant number 3 on 6/2/2002, and thus deprived his other brothers. Subsequently to buying the suit land and house, the plaintiff went to his place of posting in Arunachal Pradesh, keeping the house under lock and key, as the plaintiff did not inform the defendant number 1 and his mother about buying the suit land and house. Defendant number 1 made inquiry and came to learn about the purchase of the suit land and house in the name of the plaintiff. Defendant number 1 told his mother about it. Defendant number 1 and his mother got shocked to learn it. Around 1 p.m. on 5/4/2002, your lordship. Around 1 p.m. on 5/4/2002, defendant number 1 and his mother, Saliabala Dev, his wife and 2-year-old daughter, left their house at village Srivani and entered the suit house by breaking the lock. Period is from 1/4/2002, your lordship, and purchase was made on 6/2000. 5/4/2002, your lordship.
5/4/2002.
2, your lordship. Now, lordship may see the title suit judgment, judgment and decree in the title suit. Your lordship may find it at page number 29, your lordship. Page number 31 is the issues, your lordship. Page number 31, your lordship. On the above pleadings of the parties, the following issues were framed by my learned predecessor. Is there any cause of action to whether the plaintiff has got right title interest over the suit schedule land, whether the defendant disposes the plaintiff illegally from the suit schedule land, whether the plaintiff is entitled to relief.
Page number? Page number?
Page number 31, your lordship.
Yes.
These are the issues in the bottom, your lordship. There
Mm.
are 5 issues were framed. 2 and 3 mainly relevant. Whether the plaintiff got right title interest over the suit schedule land, whether the defendant disposes the plaintiff illegally from the suit schedule land, whether the plaintiff is entitled to relief decreed is paid for. Now on the next page, your lordship, issue number page number 32, issue number 2 and 3, your lordship, that may be perused. These issues are whether the plaintiff has got right title interest over the suit schedule land and whether the defendant disposes the plaintiff illegally from the suit schedule land. PW1 deposed that he purchased the suit land and house in the year 2002 and exhibited the certified copy of the sale deed number so and so. During the cross-examination, the defendant objected to Exhibit 2, the same being certified copy. The Honorable High Court Lordship, I am skipping this, para 10 Your Lordship. Next page, Your Lordship. They have admitted, Your Lordship, certified copy can be admitted in the evidence, and so though is a secondary evidence. This has been discussed, Your Lordship. Para 10, DW1. In his cross-exam, he admitted that the suit land and house belongs to the plaintiff, and in his cross-examination, DW1 deposed that on 5/4/2002 at 1 p.m. his wife and daughter along with their belongings entered into the suit house after breaking its lock. On perusal of the Exhibit 2 and from the admission of DW1, it is well clear that the suit land and house belongs to the plaintiff. DW1 deposed that he has been residing the house suit land since the year 2002 without any disturbance, without any interruption, and claim title over the suit land by way of adverse possession. The defendant in the written statement and DW1 in his evidence deposed that the plaintiff purchased the suit land from the sale received from selling their ancestral property. However, in his cross-examination, DW1 deposed that their inherited property situated at village Sribani was not sold by the plaintiff but by the defendant 1 and his mother. So the contention of DW1 that the plaintiff purchased the suit land from the sale proceed of their ancestral property is not justifiable. The plaintiff being not a party to the sale. DW1 deposed that he left his village Sribani in the year 2002 and since then he has been residing in the suit land. As such, he has acquired title over the suit land by way of adverse possession. Now, paragraph 11, Your Lordship. Adverse possession is a doctrine under which a person in possession of
That's
land.
right. In respect of adverse possession, no issue was framed.
No issue was framed on page 34, Your
And
Lordship.
no statement was made in the written statement also.
WS we have made, Your Lordship.
Pardon?
In our WS, Your Lordship, written statement, Your Lordship, we pleaded for adverse possession, Your Lordship. No counterclaim was made, Your Lordship. Page number 34, Your Lordship, middle para, Your Lordship. No issue was framed. The defendant 1 claimed that he entered the suit land in the year 2002. From the middle, Your Lordship, the exhibit 4 order of the chairperson of municipal board Hailagandhi. Lordship, get it? Which is proved in original. The period of limitation to claim title by adverse possession is 12 years, and during that period, the possession of the adverse possession has to be continuous and uninterrupted. In the present suit, in view of Exhibit 4, it is seen that trade license of defendant number 1 was revoked as the plaintiff did not grant the NOC to the defendant number 1 to carry on business in the suit land. Exhibit 4 also mentions the plaintiff as the original owner, and the order was passed as it was brought to the notice of the chairperson by the plaintiff by his petition dated 4/6/2013. The defendant number 1 claimed that he entered the suit land in the year 2002 and he has been continuously there without interruption. However, in view of the Exhibit 4, it cannot be said that his possession for 12 years or more remained uninterrupted as objection petition was filed by the plaintiff before municipal board in the year 2013. DW1 deposed that the suit land is in the name of the plaintiff and all other documents regarding taxes, electricity bill, etc. are also in the name of the plaintiff. DW2 in his cross-examination deposed that the defendant number 1 entered into the suit house in the year 2015-16. Thus, the claim of the defendant DW1 that he entered into the suit land in the year 2015-16 is contradicted by DW2, which again creates doubt regarding the defendant number 1 claim of adverse possession, Your Lordship. Two things, Your Lordship. One thing is that Exhibit 4, Your Lordship, that was rejected based on a objection petition filed by the plaintiff, respondent 1, Your Lordship, way back in the year 2013. Lordship is to consider, Your Lordship, cancellation of trade license, your lordship, in the way at the instance of the respondent number 1 doesn't mean that I was not in possession. The suit was filed in the year, your lordship, 2016. And lordship may kindly see this in the record, your lordship, evidence, your lordship, PW1 and PW2. I'm just small 2 paras, your lordship.
Page number?
Lordship, it is in record, your lordship. File C. I flag mark, your lordship. Green color flag mark, your lordship.
Yes.
Since in the middle portion, since the 1990, I am residing in different places in connection of my service. I was in Badarpur for 12 years and I had service quarter also. From 2002 to 2014, I was at Badarpur. So your lordship, in his cross, your lordship, he is admitting that he was in Badarpur, he had service quarter. He never lived there in the suit schedule land, your lordship, in the suit house, your lordship. And next, your lordship, PW2. I have flag my dealership. That is ignored by the Ghana trial court dealership. It is not a fact that from the date of purchase of the suit land, defendant number 1, Dayamaya Dev is the appellant here, your lordship, had been residing in the suit premises. From the date of purchase in the year 2002, your lordship, from the date of purchase after 2-3 years, that is basically is supporting my contention, your lordship. Now, only thing is, your lordship, they have, at the instance of the respondent number 1, your lordship, my trade license was cancelled and suit was filed in the year 2016, your lordship. Whether cancellation of the trade license at the instance of the respondent number 1 mean that, your lordship, I was not in possession until plea, your lordship. In between, your lordship, nothing. So whether they have filed the suit within the period of limitation.
What is the written statement?
Written statement, yes, the lordship will find at page number 17 onwards, your lordship. Annexure 2, page number 17, your lordship. Limitation.
The plea of adverse position was taken in the written statement.
Lordship?
Plea of adverse position was taken in the written statement,
Yes, Lordship.
but no issue was
No
framed.
issues, friend. That is one aspect.
And to the suit premises is in your possession since 5 to 2002,
2002, Your Lordship.
and the limitation period over in the year 2014.
Lordship, they filed the suit, first pleader notice on 17/10/2015, Your Lordship. And suit was filed on in the year 2016, Your Lordship. Yes, Lordship.
So the
4/6,
limitation period
2006.
over in the year 2014.
Lordship, 4/6/2016, they filed the suit, Your Lordship.
No, no. If the limitation period is 12 years,
Yes, Lordship.
then the suit ought to have been filed on 4th of April
2014, Your Lordship.
2014.
Yes, Lordship. As per
So it
limitation
was
section
filed in the year 2016.
Your Lordship, 4/6/2016. As per Article 64 of the Limitation Act, Your Lordship, it provides 12 years.
Hmm.
If it is within the period of limitation, then it goes against me, Your Lordship. And if it is not within, then it comes in. Because
But
I
the
am
question
still in
is
possession.
how you have entered there. That has to be looked into.
Yes, Lordship.
Yes. What is your case?
Then take and dependent number one matter private.
Pardon?
Yes, brothers, brothers,
Brothers.
brothers.
Hmm.
So it is a self-acquired property. Your Honor.
Self-acquired property.
Yes, self-acquired property of the plaintiff.
Hmm.
So the plaintiff is claim is simply stated. And
No, no. Self-acquired
Not
property.
an
How?
ancestral
Because
property, Your Lordship. It's a purchase. It's not an ancestral property.
no, no, no.
They are brothers, biological brothers, Your Lordship, but it's not an ancestral property. It's a purchase land, so adverse possession lies. Your
That is
Lordship.
the paragraph of my claim. That there are 6 to 2002. Performer defendants, I have purchased the property from the performer defendant.
Hmm.
Page number 7, paragraph 2 of my claim.
Hmm.
So for that 6 to 2002, performer defendant number 3 sold the below scheduled land and house to the plaintiff. Today, after sell it and delivered our possession thereof to him, being the owner and possessor of the said property by way of person, the plaintiff renovated the house, made it for living. So this is the property of the plaintiff, Your Honor. How the defendant number 1 came to the property, I am referring it paragraph 4. Paragraph 4.
Hmm.
That the plaintiff with the intention to his old mother allowed defendant number 1 to visit house to the plaintiff at Hailakandi from the house of defendant number 1 in the village Srivali for looking after old mother of the plaintiff. But the cunning and sure defendant number 1 along with his family under the instigation of wicked person in the locality started staying in the house of the plaintiff without his permission and knowledge and set up a business there by opening a stationery shop, defying the strong objection of the old mother of the plaintiff. Defendant number 1 illegally gave a room to the defendant number 2 on the rental basis. Thus, he has been earning a huge amount. And what he claimed, Your Honor, in their WS, page 18, last line, Your Honor, page 18. Your Honor will find it.
Mm.
Last line. Around 1 p.m. on 5/4/2002, defendant number 1, his mother, his wife, and 2-year-old daughter left their house at Savani and entered the suit house by breaking the law. This is the adverse position that they have claimed. From that they are in adverse position of the suit property.
Mm.
But in evidence, they fail to provide any evidence regarding their adverse position. I'm coming to the point now. It is been deliberately discussed by the trial court in paragraph 10, 11, and 12 in its judgment. Your chief, this issue. What is my, what is already here, no? Paragraph 10. Admitting, DW is admitted that Suitland houses belongs to plaintiff. This cross-examination DW1 deposed that so and so that at 1 p.m. his wife along with daughter and belonging entered to the suit house by breaking the law. On perusal of Exhibit 2 and from the admission of DW1, it is clear that the Suitland and house belong to the plaintiff. So it is admitted, it's clearly admitted that house belongs to the plaintiff. And I am coming to that point, Your Honor. Yes. Next line, Your Honor. DW1 deposed that he has been residing the Suitland since 2002 without any disturbance, without any interruption, and claim title over the Suitland by way of adverse possession. The defendant in their written statement and DW1 in evidence deposed that the plaintiff purchased the Suitland from the sale proceeds received after selling of their ancestral property. However, it is important, Lordship. However, in its cross-examination, DW1 deposed that their inherited property situated at Village Silvani was not sold by the plaintiff, but by the defendant number 1 and his mother. The plaintiff never said any ancestral property. So they are claiming that it is the proceed of the ancestral property. This is also not established, Lordship. And I'm just skipping the order. Coming to the 11 here, Lordship. Adverse possession doctrine under which a person in possession of land owned by someone else may acquire valid title to it, so long as certain common law requirements are met and the adverse possession in his possession for a sufficient period of time as defined by the statute of limitation. The expression adverse possession means a hostile, that is the possession which is in denial of the title of the true owner. But he denies my title. Yes, it is the owner. He has purchased the land. I'm coming, Lordship. It must be adequate in continuity, in publicity, and extent to show that it was adverse to the real owner. PW1 deposed that he allowed the defendant number 1 to reside in the Suitland and house to look after his ailing mother, as PW1 was posted at Rangya. PW2 and he corroborated this evidence of PW1. The PW deposed that the defendant number 1 started running a stationery shop in the Suitland and obtained a trade license, and when plaintiff came to know about, he gave an objection before the chairperson municipality board Hailakandi. Accordingly, the trade license of the defendant number was revoked by the order dated 4/9/2013. So after my objection, the trade license was revoked by the municipality. This is the Exhibit 4, order of the chairperson, municipality board Hailakandi, which is provided originally. The period limitation to claim title by adverse possession is 12 years, and during that period, the position of adverse possession has to be continuous and uninterrupted. In the present in view of Exhibit 4, it is seen that the trade license of defendant number 1 was revoked, as the plaintiff did not grant the NOC to the defendant number 1 to carry on the business in the Suitland. Exhibit 4 also mentioned the plaintiff as the original owner, and the order was passed as it was brought to the notice of the chairperson by the plaintiff by this petition dated 6/4/2013. The defendant number 1 claims that he entered the Suitland in the year 2002 and has been continuously there without interruption. However, this is important, Lordship. However, in view of Exhibit 4, it cannot be said that his position of 12 years or more remained uninterrupted, as the objection petition was filed by the plaintiff before the municipal court in 2013. DW1 deposed suit land is in the name of plaintiff, and all other documents regarding tax, electricity bill, etc. are in the name of the plaintiff. DW2, it is a witness of the defendant. DW2 in this cross-examination deposed that the defendant number 1 entered into the suit house in the year 2015 and 16. So this is his witness. Thus, the claim of the DW1 that he entered into the suit land in the year 2015 to 16 is contradicted by DW2, which again creates doubt regarding the defendant number 1 claim of adverse position. That's it. Number 12, this is the finding of the, and I am taking to the proceed.
So,
Please.
Mr. Okay,
Please,
Mr. Chaudhary, so DW2 is your witness?
Yes, Lordship.
His witness.
For my lapses,
So,
Lordship, they
your
cannot-
witness deposed that
Yes,
you
Lordship.
entered the suit land in the year 2015 and 16.
Yes, Lordship. That is
So
why I have
how
referred.
how the adverse position, plea of adverse position can be taken?
For my lapses, they cannot get benefit because Lordship, that is why I have Lordship referred the PW1 and PW2. I have relied initially, Your Lordship. PW1 in his cross, Your Lordship, specifically stated, PW1 is the plaintiff, Your Lordship, here respondent. What is stated, Your Lordship?
Taken by the defendant. But
Yes, yes, I admit. Since in the year 19, Lordship, in the year I am coming to that. Since the year 1990, I am residing in different places in connection of my service. I was in Badorpur for 12 years and I had service quarter also. He was residing in his service quarter for 12. From 2002 to 2014, I was at Badorpur. So he has been specifically admitted he was in Badorpur from 2002 to 2000
Maybe,
service quarter.
but
Now, I'm coming to this point. Your
he
Lordship.
filed a complaint in the year 2013 for cancellation of the
Yes, Lordship.
NOC.
Yes, Lordship.
No, sorry, trade license.
Yes, Lordship.
And the same was cancelled on 4/9/2013.
Yes, Lordship.
So how can the position
Lordship.
right to be uninterrupted then?
Yes, because Your Lordship, my trade license has been cancelled at the instance of the plaintiff respondent, Your Lordship. It doesn't mean that I was not in possession, Your Lordship. Had it been, then as to why they have filed a suit in the year 2016, I am not on that, but still, Your Lordship, mere cancellation of the trade license of a shop, Your Lordship.
No, we are not concerned with that, but he lodged complaint about cancellation of the
Exhibit
trade
4
license.
the trade license, Your Lordship.
Yes. So he has disputed your claim.
Yes, Lordship. And PW2 in his cross has stated that
Then, moreover, DW2 is your witness.
DW2.
He testified that you entered into the suit land, suit premises only in the year 2015 and 16. Then the suit was filed in the year 2016.
Your Lordship.
So
PW
where is the how the ingredients of
adverse
position is being proved?
Lordship may find PW2, it is their witness, is stating that I know the MO after his coming to Hailakandi. He came to Hailakandi after 2-3 years of purchasing the suit land. And present suit and purchasing the suit land of the present and entered into the suit premises. It is the PW2 statement, Your Lordship, in cross, and PW1, who is the plaintiff respondent, he himself stated that he was there in Badorpur, Your Lordship, from 2002 to 2014. PW2 is the witness of the plaintiff respondent, specifically stated that I know the MO after his coming to Hailakandi. He came to Hailakandi after 2-3 years of purchasing land of the present suit land and entered into the suit premises. The Learned Trial Court only considering the DW2's, it is there in gray areas there, but similarly, Your Lordship, PW2 has stated.
Why should we disbelieve your witness?
For my lapses, Your Lordship, PW2's cross is there, Your Lordship. I have flag marked, Your Lordship. These aspects has been ignored, your lordship. PW one statement, PW two in cross, your lordship.
Maybe, but you are not ignoring that, you are not disputing that complaint was filed on the basis of which your trade license was cancelled.
Yes, lordship.
Then
But mere cancellation of
how
my,
it can be, even if it is assumed that you have entered into the suit premises in the year 2002,
yes, lordship.
can it be said to be uninterrupted?
I was not dispossessed, your lordship.
Huh?
I was not dispossessed. My trade license was cancelled, your lordship.
Mm.
But still I was there, your lordship. My dispossession was not.
Maybe.
I was-
Over and above, TW2 testified that you entered into the suit line in the year 2015 and 16.
Yes, lordship. In this
Then
case, he stated. And in this
where
regard,
is your case?
in this regard, your lordship, PW2 in his cross, your lordship, stated that I know that after his coming to Hailakandi, he came to Hailakandi after 2-3 years of purchasing land of the present suit and entered into the suite premises. PW2 stated that 15-16, PW2 is saying that PW, and in this regard, PW1 also stated that from 2002 to 2014, he was at Badarpur, your lordship. PW1 and PW2, your lordship. This is the witness of the
When the suit line was purchased by the defendant?
suit land was purchased, your lordship, on 6/2/2000. On 6/2/2002, your lordship. By the plaintiff.
2002.
6/2/2002, your lordship.
Any other point?
No, lordship,
No.
this is the limited. So
Any
for
concern?
DW2 is
Yes, I'd like to refer page 54.16 of the appellate court judgment. Page 54.
Page number?
Page number 54. And number 16. Yes, I'm reading it. In this regard, the plaintiff, PW1, reiterated that since he used to stay at places for each job, he brought his mother to stay in the house at Hailakandi in the year 2014, and also asked the defendant number 1 to look after his mother and the property. He has retained his stay in his cross-examination also. In his cross-examination on query made by the defendant, he has clarified that only after expiry of their mother in the month of July 2015, the defendant number 1 came into the possession of the land, which corroborated with the TW2. TW2 said that 2015.
Then as to why, your lordship, trade license petition was made way back in the year 2013 for cancellation of the trade license. If I entered in the year 2014 or say 2015, your lordship. Petition for cancellation of the trade license was made in the year 2013.
My mother.
In the year 14, your lordship.
In para 4, I am reading already with intention of this old man, allow defendant number 1 to visit the house of the plaintiff at Hailakandi from the house of defendant number 1, the village so for looking after the old mother of the plaintiff.
Old mother of the plaintiff was received in the year, when he got transferred in the year 2014, then he stayed his mother in his, back in the suit premises, your lordship, in the year 2014. But here, your lordship, exhibit 4, application for cancellation of the exhibit 4, that is the trade license was made in the year 2013, your lordship. It was cancelled in the September 2013, your lordship.
Behind my back, behind my, that is why when I came to know that I.
And that about, your lordship, in the next paragraph,
And they cancelled it accordingly.
paragraph
I know that.
16(1), your lordship, PW2.
I go for cancellation.
That was not considered, your lordship, that I have pointed, your lordship.
No, that's all right. The problem is that in second appeal, we cannot
Yes, I
reappreciate
understand,
the
lordship.
facts.
Understand, lordship. Only thing is that, your lordship, whether mere cancellation of the trade license
Mm.
in the year 2013.
Forget about exhibit 4. What about your evidence, DW2?
Tier 2
Hmm?
categorically stated that I entered in the 2015-16.
And
In this regard,
DW2, the evidence of DW2 corroborated the evidence of PW1 and PW2.
Yes, Lordship. No, PW2 stated that, Your Lordship, PW2 stated that I entered in the year just after the purchase, after 2-3 years of the purchase. PW, that is why I am referring, Your Lordship, in the suit premises. PW2, Lordship, I have phlegmat, Your Lordship.
Mm.
In the law. PW2 stated not corroborating, Your Lordship. And PW1 also, Your Lordship, stating that from 2002 to 2014, I am
Mm.
staying at Bodorpur in a quarter, Your Lordship, service quarter, Your Lordship.
Mm.
In his cross, Your Lordship, he has stated, Your Lordship. I have
He has
phlegmat in
never visited his place.
visited, Your Lordship. That is one
Should be
aspect.
myself.
But so far as my learned friend is relying on DW2, Your Lordship, I am in this regard, I am showing that PW1
No,
himself,
not only he had relied upon the DW2,
PW2
but,
also stated.
but courts below also relied upon the same. Hmm?
PW2 also stated that in the year 2002 I have entered. PW2, Your Lordship, in the cross
Hmm.
file C, Your Lordship, I have phlegmat. In his cross, he has stated that, Your Lordship.
Hmm.
I know Dayamaya, after the coming to Hailakandi, he came to Hailakandi after 2-3 years of purchasing land of the present suit and entered into the said suit premises. This is the cross of the PW2, Your Lordship.
Hmm.
DW2 has stated that in the year 2015-16, I entered. PW2 has stated, Your Lordship, just after 2-3 years, I entered in the suit, land in the present suit and entered in the suit premises. There is just after purchase.
Okay, any other point?
See, even the PW2 and PW3, they already I am it is stated in 65 of first appellate court judgment,
Hmm.
point 16.1 and point 16.2.
Hmm.
and point 16.3. So I am reading it, Lordship. It is 55. The PW2 Amalendra Bhattacharya, who is an independent witness, also deposed supporting the contention raised by the plaintiff to the effect that the suit property was purchased by the plaintiff, wherein he brought his mother to his stay, and with her consent, the defendant number 1 was allowed to stay only to look after their mother. Even there, this witness in his cross-examination stated categorically that the repairing work was also done by the plaintiff. The evidence of this witness has also remained unrebutted by the defendant. 16.2, Lordship. The PW3, Nilamoy Dev, who is the other brother of the plaintiff and defendant number 1, also reiterated that the suit property was purchased by the plaintiff from its own source of income and not by the plaintiff for the money given by their fathers. On 16.3, from Exhibit 7, it appears that the notice dated 17/2015, Exhibit 5, which was sent to the defendant number 1, diameter by register post number so was duly received by the defendant number 1 in March. A signature on ID card is very much clear therein. In the same notice, the plaintiff narrated the entire fact pertaining to his ownership over the suit property, induction of the defendant number 1 as a permissive occupier to look after their mother and or as a caretaker thereof, with a request to vacate the suit property. However, the defendant number 1 did not reply to that notice. Non-responding the said notice reflect the contention raised by the plaintiff are correct. Otherwise, the defendant number was supposed to be respond the same. So this is the finding of the first appellate court.
17 and 17.1, that may be very different. I'm not denying that the plaintiff respondent is the owner of the suit property, Your Lordship. I have agreed with that.
Do you have the translated copy of the examination in chief of the PW1 and PW2? It is in vernacular. No. You do not have the translated copy. Okay. Heard Mr. R.S. Oduri, learned counsel for the appellant, Mr. Your name?
Madam Chikakote.
Chikakote for the
Number one.
for the respondent number 1. You for? Same. Okay. Same. Heard in part, list the matter immediately after reopening of the BU vacation. And in the meantime, registry shall translate the evidence of PW, no, examination in chief of the PW1 and 2. And also the plain and written statements are also in vernacular.
Yes, sir. I have translated.
The plain and also the written statement and the cross-examination.
DW's chief lordship.
Cross-examination of DW1 and 2. DW1 and 2. So list the matter as parted.
Lordship, DW1 and 2 procedure in English, Lordship, but chief is in
That has to
vernacular.
be typewritten.
Chief may be typed, Your Lordship. DW is 1 and 2.
DW?
1 and 2, chief may be translated, Your Lordship. DW1,
Yes,
evidence
yes,
in chief.
dictated.
Like that.
May I please have it? The material fixed after vacation management.
10:30 is very important. It's so that the RBX file.
2025
Maybe,
meter.
but it is
It
time is over.
minor.
Minor time code execution page cases not including proceedings person waiting for the order of the High Court and for the landlord, my lord. So bona fide requirement was there. So we are on concurrent findings. So
My 2021 suit was filed on 2021 matter, and his matter is pending to this matter 25 matter.
this case was filed in 2025. Eviction petition earlier. We have prior to this we have filed the execution case and it was also issued. And thereafter, my lord, because of the tendency of this eviction petition, court is not inclined to pass an order. We have to
Suggested that
Tuesday, next Tuesday, my lord.
No, after vacation matter.
Tuesday possible. No, yeah, madam, you see,
Huh.
the registry has issued a notification that the coming week will be only
Yes.
Motion.
So immediately after being open.
Yes, immediately after.
Fixed for timely, my lord.
Okay.
Otherwise.
Okay.
28
23rd.
matter. 28 matter.
No, my lord.
He has consented matter. She has consented to my senior matter.
It will be very lengthy, my lord.
28 matter. 28-4.
Considered means
Consented.
I mean, consented matter. And my senior has left, may not be.
who is your senior?
J. Roy matter. See, he discussed with her matter.
28.
Yes, so twice the matter was listed, but due to paucity of time.
The 25 matter, so matter in the later part it is listed matter.
Okay. as agreed by learned advocates of both the parties, recessal is the matter on 28 April.
my lord.
Okay.
April.